And I think I'm live. Uh, so, hi kids. Today, I'm basically doing a test stream. This is my very first live stream, so welcome. I'm going to be reacting to the final pretrial hearing for Darrell Brooks, the Waukesha Christmas Parade attacker, uh, mass murderer. Uh, the jury has been selected. They finished that as uh, quite remarkably in 2 days, finished yesterday. They have 16 jurors, 12 will stay on to deliberate, 4 are alternates. There are 10 men and 6 women, all white. Uh, and hello, Static. It has been a long time. I've been a little too lazy. I'm hoping to be more active. I've set a personal commitment to stream the whole trial. I hope to stream more trials in the future. Uh, I'm hoping that the Daybell Vallow trial is streamed. It's up in the air at the moment because I'm of the law tubers. I realize I'm about as small as they come. Oh, thank you. That's very kind of you. But but yeah. So of the law tubers, I'm small, but I have the unique perspective that I'm in Utah, grew up Mormon, so I I'm going to provide both legal and cultural commentary on that one. So this is kind of a practice run, live test stream today. Um ah well, uh, considering there are 3 million Utahns out of 7, almost 8 million people, it's impressive that the 2 people on here right now are both from Utah. So, uh, and I'm going to fiddle with my phone for a minute. My spare monitor has decided not to work, so I'm going to pull up the YouTube Studio on my phone if it wants to get unfrozen. Um, so that I can see the YouTube Studio type stuff. Um, but yeah, so I have no idea what's going to happen in this pretrial today. I have an idea though. Uh, let me see. Get this working. But oh, it looks like the video has started. So let me make this full screen in there. All right. And I'm not hearing sound from the video. I think I have the sound on. I hope I have the sound on. We'll see once it gets going. I hear it now, or at least I heard something for a second. So I'm going to go with the assumption that the sound will come on, um, since the hearing still hasn't started quite yet. Um, but so during the jury selection, Mr. Brooks was kicked out of the courtroom multiple times. He brought up most of the standard sovereign citizen rhetoric, including a new one to me, really. He asked the judge incessantly what her name is, which is silly because her name's on a placard on her desk. It's there, it's available. And I'm I'm not quite sure if he's trying to go down the sort of straw man route, trying to claim the judge is an illegitimate entity or what, but he asked incessantly her name. He Every time they went to recess, I don't know. Um, I guess I should highlight the comment I'm using. Like I said, first live stream. Um, Funny enough, I'm 38. I never took a civics class in school. At least, yeah, at any level. Um, but I think the most common reason that sovereign citizens exist is desperation. That they're they find themselves basically at a point where they have nothing left to lose, and so they may as well try something stupid. But it's I think it spreads through mostly through either jailhouse lawyers who someone's arrested, they hear from a fake guru in jail who says, "Well, your lawyer's dumb. Try this," and they do, or they are desperate in a family law situation and they are trying to either keep custody of their kids or get out of paying child support. And once again, they're desperate, so they try something stupid. That's a increasingly rare talent, unfortunately.
The court will call State versus Brooks, case number 21, CF 1848.
All right.
May I have the appearances, please?
How's the volume level
Leslie
between
Daisy and Zach
me
Wichello,
and the
Kansas City,
hearing
Wisconsin.
now that it's started?
Sir, state your name for the record, please.
I'm here as a third party intervener in that matter, appearing as authorized representative from my client. I accept for value and return for value all the charging instruments in this matter and make my exemption available
All right.
for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
I'm going to try not to pause it, so
Also, Your Honor, I would like to make an offer for my appeal, if I may.
Um,
every
I'll
word
get
he
to
said
that
there
momentarily.
is
The
either
record will
irrelevant
reflect that
or total
the
BS.
individual known to this court to be Darrell Brooks, is appearing in person in custody. We are, of course, outside the presence of the jury today. Since they are not here, we are dealing with some housekeeping type of issues and other legal matters. So he is appearing today in jail attire. He is in custody. And it's my understanding, Mr. Brooks, that you were offered to appear in the suit, but chose to come to court in jail attire, which is fine. We're not in the presence of the jury. I just wanted to make a record of that.
He has the opportunity to wear a suit, so the orange jumpsuit doesn't prejudice the jury against him.
To reflect that, if I may.
The record will reflect. Thank you. All right, I know there was some filings, and I want to make sure the parties have copies of everything. Mr. Brooks, I know there was an inmate communication form filed, I believe earlier.
That's
this
me
morning,
watching on the phone.
requesting 6 subpoenas as soon as possible. I instructed my staff to make sure ample copies of the subpoena forms were provided to you. I did receive verification that those were hand delivered. Did you receive those?
Like I said, my monitor decided not to work, so I opened it on my
I'll
phone
provide
to
additional copies.
monitor
Again, it's my
YouTube.
understanding those were hand delivered to the jail, and that the jail took care of that in the event that that latter part did not take place. Mr. Brooks, I believe you were requesting 6 subpoena forms. I'm going to have my clerk print out 10 so that you have ample copies. And when that is done and those are handed to you, I'll make a record of
Pretty late in
that.
the day to be subpoenaing people. He had to have his
We
witness
addressed
list
the
in
inmate communication form. I sent
yesterday.
about the,
I have a number of issues I need to address, so yes, we'll get to that.
You don't believe that has that's an important issue that should be taken up before we continue any further in the proceedings?
I just want to make sure the state has a copy of what was forwarded first before we take that up.
Will
So
they?
I'm not seeing it in the record yet, so.
Sounds good. What are you farming?
5, so it'll refresh.
Our tomatoes have done
the prosecution
terribly
will
this
receive a
year.
copy?
It's been too hot
I
for
believe one
them.
was printed now for them. It is in the record. And then I'm gonna print off something as well. I don't know if it was already.
Your Honor, I respectfully would like to state for the record and would like the record to reflect that I believe that this is an issue that should be addressed at this point before we go
Sir,
any
I'm
further.
preparing to do that. I didn't say I wouldn't do that. So give me a minute. I have some documentation that I'd like to provide to the parties as well. And I want to confirm with Attorney Opper that you have now received a copy of that inmate communication form.
Yes, I have one in front of me, Judge. It's dated today's date, October 5,
Oh, wow.
2022.
Yes, dated today because I just learned of the protocol that I would be on as of today.
My brother lives next door, and we have kind of a shared backyard
All right, I'm gonna
here in the
provide,
Sugar House area.
a
And
document
he
to
has
the parties. It's a 5-page
15, 20 chickens,
document.
2 turkeys, and a corgi.
It is a document that was forwarded to me at my request by Monica Paz, our clerk
And
of court, after
unfortunately, lots of
receiving
squirrels.
the inmate communication form from Mr. Brooks requesting an adjournment. For the reasons stated in that document, I thought it important that we all have before us the current county protocol related to COVID-19. And so this will be provided to the parties.
Now, decline
Is
to,
your farm in northern Utah?
Accept that if I don't believe
Sir,
that it's.
it will be
well,
placed on your table, but I will be referring to that today, so
is
it's
it
been
law?
given to you.
Is it verified law, Your Honor?
Attorney Opper, do acknowledge that the COVID-19 illness reporting protocol was
respectfully
provided.
I respectfully object.
Yes, Judge.
Your Honor, I would like an answer to that.
Speaking
question,
of
if I may,
that plague that YouTube doesn't like mentioned,
'cause I've
if I
not
have coughing
consented to
fits,
or agreed
that's
to
what it
accept
is.
any paperwork
I've
that
tested negative by now, but
Sir, it's been
He's not
provided
moving.
to you.
I'm still
It's
So are you
something I'm going to
making
consider.
a
You
little
don't
bit
wanna read
recovering.
it.
Are
You want to
making a
disregard it, that's
judicial-
your choice.
Are you making the judicial determination that you don't have to answer that question I just asked you, Your Honor?
Mr. Brooks, the COVID-19 protocol has been placed in front of you. It is
Ah,
your choice
all
whether
right.
you want to review it or not.
At some point, one of my goals,
So my
I don't
understanding,
have any interest in cars right
just from the
now, but
information
I'd like to
Mr. Brooks has
start
provided, which
a
is part of the
second
public
YouTube channel
record, is
doing automotive
he's
stuff,
requesting an adjournment
buying cool
of all
cars and driving
proceedings,
them around.
due to learning
And
that he's on
I'd
the
like to get out to
COVID-19
your
protocol.
area and
I don't have any other information.
try
on
out the
that, sir.
racetrack.
But based upon,
I've never driven on it, but I hear it's world class.
again, I did grab, I didn't grab, I was provided with the COVID-19 illness reporting protocol. I wanted to make sure that I had the most recent information.
My parents
that
went
the-
to
that the
Boston
county of
and thought it would be a
Waukesha,
good souvenir
is
to take
operating
home.
under.
And
I also verified
my
your
only
reports
exposure
that
to them
at the location at
was
which you are
picking
seated
them up from
is
the
not
airport,
within
but
6 feet of
that
any
was
other
enough.
individual in this courtroom.
And
Um,
I was
Is there
dumb.
any other information
I
you
made them
think I
take
should know as
the
I consider your request for
antivirals right
adjournment
away,
today?
but I didn't.
Yes,
And so they got over it real fast. But even though I had a
I
mild
find
case,
it hard to believe
just
that you couldn't
will not
consult
go
with,
away.
Jail staff to verify the protocol, to verify that I was seen by nurses that
I don't have that
specifically-
information, sir, and let me be clear, cannot be provided to me under HIPAA. The only information I have
my dad
is
had a
what you put in the inmate
1975
communication form.
Datsun
verified
280Z.
because I was told when I was brought
My
down
cousin
here
has
that
it now.
Everybody knew that I was on a COVID protocol. That's
And
why everybody.
Because
I
they
used to
advised
take
us.
it
That's
bombing
why,
up and
no,
down
because the jail
Immigration
advised
Canyon.
me. That's why they had to wear masks
I'd like
to
to
bring me down. That's why
convince my cousin to let
I'm
me take it out to the track,
essentially on a
assuming
protocol
I can
that
even drive
doesn't
it
allow me out
anymore.
of my cell until my
You know,
results
Uh,
come back.
as
So
I
I'm not
mentioned in
allowed
my
out of my cell
intro
at the
video,
moment because of the
I'm
protocol
an above
that
knee
the nurse
amputee, so
himself placed me on, that
using the
jail
clutch
confirmed.
could be a problem. But
that is very easy information.
I haven't
to
driven
obtain.
it since, but I
Sir,
have
have
tried the
the,
clutch
an
and
attorney
can work
for the
it.
county
So
here
I
who
don't-
will
gonna try
verify
it.
I
that
don't
none
want
of
you to
that
think I'm trying to
information
argue
has
with
been
you, Your Honor.
provided to me due
I
to
don't-
HIPAA.
I don't want you to think I'm
requirements.
arguing.
I don't want
So
you
I'm not
to think I'm
arguing with you,
arguing,
sir,
I know, I
one
but I'm
bit.
going to
know that
argue.
I'm not arguing with you either, but I was right in the middle of finishing what I was saying.
So I need to stop you for a minute, Mr. Brooks,
I don't
because
consent to that, Your Honor, because
you don't have to consent,
I
but here we
don't
go. Let
consent or
me,
agree to being cut
Judge
off.
said it perfectly.
right when
His
I'm trying to
all right,
consent
I'm just
isn't
gonna talk over
required.
him for a
Information.
minute. I do not have any other information regarding, the COVID-19 protocol, meaning anything specific about you, Mr. Brooks, other than what was put in the inmate communication, which reads, due to just learning I'm on COVID-19 protocol, I respectfully ask for all proceedings to be adjourned at this time, which is why I asked you if there was any
58
other
54 Bel Air
information you
is
wanted
good
to
looking.
provide me as I consider
My
your request, because the jail has
absolute
not
dream
provided me
car.
with any specific information regarding
And it's been
the
my dream
reason
car
you
since
were
before I
placed
knew
on
the
protocol,
price
whether
of
you
them.
were
So
exposed whether you
It
are
being
showing
the
symptoms.
now
They
second most
cannot
expensive
provide me with
car
that
ever,
information
has no
absent you
bearing, but
giving
the
them
Ferrari
permission
250
by
GTO,
signing an applicable
that's the
authorization to
absolute
do that.
dream
Without
car.
that, I have to rely upon you to provide that information to me
That is-
if you so choose.
That is incorrect because just yesterday you were trying to obtain the witness list that was in my cell. You had no problem whatsoever having the JA come down here to have me verify that they can go in my cell and search for that. So I find it very hard to believe that you can't consult with jail staff for them to tell you what is going on in my situation, where they know that I've just been seen by a nurse that placed me on this protocol for having a loss of taste, fatigue, and I have to wait for the results of my test. And until then, I am on a protocol which restricts me to my cell. That is very easy information to obtain.
Muscle
And I
cars are
find it very
great
hard
too.
that Your Honor cannot obtain that information, but can obtain a way to communicate with jail staff when there's a witness list involved.
I've got
We're
an
talking
eclectic
about
taste,
someone's health that
and
can affect
I think my
not just you,
dream
but anybody else,
muscle car
not just
is an
officers, but also
AMC
inmates. We're talking
AMX
about health when we're
with
talking
the
about safety. That has
390
a lot of
V8.
merit. And frankly, Your Honor, I'm afraid. I'm fully vaccinated and I've never had COVID. I don't know what I'm looking at here. I'm that was the last thing I was hoping I would be told today, Your Honor. So I'm afraid right now. I'm not feeling well. I don't know what's going on with myself. That's the reason why I put in the sick call slip initially. I had been telling officers for days that I hadn't been feeling well, but I didn't know what it was. But I felt that I had to put in the sick call slip because I was not able to taste anything. That is the reason why I was seen by nurses. That is the reason why the COVID test was administered. And that's why I'm on the protocol as we speak.
Are you willing to discuss with me what tests were
That would be
done?
cool, static.
And I
My
cannot obtain that
I don't,
information on my own.
I'm not a nurse, Your Honor. I don't know the name of the test. I don't, like
I
I
have
said,
no
I've
kids,
never
but
had this
Let me
happen.
got a
clarify that.
niece
That was
and
that was
three
a
nephews, and
pretty
they
ambiguous
love
question.
animals.
So, you reported symptoms as that's what you're telling me, right?
Correct.
And you're saying some tests were done?
I mean, that it's obvious. I mean, why can't it be verified with the nurse?
I have to verify it with you. The nurse will not provide me with this information.
But the jail can because
If you
they
don't want to
control the
put the
movement. They control all
farm
inmate movement. I can't just go from my cell to a HHU.
name on the
Inmate
chat,
movement does
my
not be
my
issue at
email
the
is on
moment.
my
Not, but I'm
channel
saying, how
about
can I
page.
tell you? How can I answer what you're asking me? It doesn't make sense. We all understand that the jail itself controls the movement of the inmates. That's common sense, Your Honor.
I'm not here to talk
I
about
can't- I
inmate
can't
movement
just-
at the
I can't
moment. What
just
I'm
walk to
asking
the
you is,
HSU.
do you believe you were tested for COVID?
I obviously was tested for COVID. I would not be on the protocol if I was not.
Do you know
The
what
nurses-
type of test? Was it an oral swab, a nasal swab?
It was a nasal swab.
All right. Do you know when the results of that test will be back?
From my understanding, Friday.
This isn't the argument I was
That's
expecting
what I was
for
told by the
today.
doctors. I would have to be at least on this protocol until the results come back, which
Were you-
he said the earliest would be Friday.
Sounds good.
Were you offered a rapid test?
They said they do not do the rapid test.
So you weren't offered a rapid test?
They said they don't do them.
If one can be obtained, are you willing to submit to a rapid test?
I'm not willing to submit to anything right now until we take care of the issues that's at hand. I mean,
I'm
I've
sure they
already
could
been
get him
placed on the
tested before he
protocol.
leaves the courtroom today.
Frankly, I'm very afraid right now because I don't know what's going on. This is new to me. Like I said, I'm fully vaccinated, Your Honor. I've been fully vaccinated since 2021. And so
for this to just be sprung on me now to say this could possibly be a COVID thing. I've had people close to me that have passed away from COVID. I'm afraid as hell, Your Honor. That's the reason why I submitted the ICF for the adjournment. I was thinking at least until I can get the results at bare minimum. I don't think I'm asking something that's
Sir,
impossible for
if
Your
I
Honor to
can make
grant.
arrangements to have a rapid test brought to you and administered, are you willing to submit to that test?
Not at this time.
Why not?
Not at this time.
Why not?
Why can't I get the results for the test I already took?
But you're telling me you're scared, you're
Yes,
fearful.
I am. I
But you
am
don't
very.
want to take a test that might
I
tell
took-
you today.
I took the test that he gave me.
And
if
you're
he
telling me
felt-
that test result won't be available to you until at least Friday.
At least Friday, that's what I was
So
told.
tomorrow.
I was told that I would be
Sorry,
placed
day
on this
after.
protocol until the results came back. The earliest that the results would be back would be Friday.
So that sounds like, to me, I think that's what they call a PCR test.
I have no idea, Your Honor. I
Okay.
have no idea what it's called. Like
Let
I
me
said,
ask
I've
you-
never had COVID. I don't know the test names. I don't know what they call them.
I'm generally familiar with some of the testing for COVID. There are tests that can be what we call rapid tests,
Huh.
or what are called rapid tests.
I thought
that
I
are
had the email
available.
on there.
And then there's
Oh,
these
It's
other tests which take a few
peglegfinance at
days. And it's- Again, I'm
gmail.com.
not a scientist, but I think the general belief would be
just my
sometimes the
channel
rapid
name is
tests
one
are
word.
accurate, sometimes they're not. Sometimes people test negative when they're really positive. It just kind of depends on the circumstances. But it's my understanding a positive test would be pretty accurate. And then there's other tests that take a few days for the results to come back. It really depends on the lab that's being utilized, et cetera. I'm asking you once again, if a rapid test can be obtained, are you willing to take a rapid test?
How would that be obtained? How would it be obtained?
I would
was
work
told
with,
I can only go by what was told to me, because when I was brought in there and they told me that they had to test me for COVID,
If you gave
I
her
was
a chance to
immediately like,
answer,
what do
she
you
could
mean
tell
have
you
to
how
even
it would
test
be
me for this?
obtained.
What is this about?
well,
I had
didn't
a
you report
lieutenant. I had,
symptoms to them?
excuse me, Your Honor. I had
She
a
can send a
lieutenant
court aide to the
and
pharmacy
two
to get a
officers
test
present
right
when I was
now.
asking all these questions. Why do I need? What's going on with this? Why is this? Why is this? Why is that? Because I didn't understand. Immediately in my head, I started to get afraid when they said they had to even test for COVID.
Well, were you reporting being sick and symptoms prior to them asking you to test?
Yes, I've told multiple officers. I didn't know what it was at first because it started with fatigue, with me feeling very fatigued. And I said, man, I don't know if it's just me being tired, or that's what I initially thought it was. Maybe I'm just a little exhausted. But I said, no. Anybody knows their body.
I think I'd be
I said,
fatigued
something-
in the
it's
run
gotta
up to
be something
being
more, 'cause I'm
tried
really,
for
really, I don't even
such
have an
gruesome
appetite. Then when
crimes.
I'm trying to eat,
But that would be because I
I can't
couldn't
taste
sleep.
anything. That's what said, okay, now I need to put the medical sick
When did you
card slip
report
in.
these symptoms to the medical people or to even just a correctional officer?
Probably wouldn't do lack of
Um,
taste though.
A few days ago. Over the weekend is when I started to notice the fatigue. So I was telling officers, man, I don't feel good. I don't know if it's just I'm tired.
When did you-
Usually I don't just jump the gun and say something's wrong, because it may just be, it could be anything. So
When did you report the loss of taste?
I reported the loss of taste last night.
And was it after that that they told you they wanted to test you?
No, they didn't tell me till this morning that they wanted to test me.
What other symptoms are you reporting at this time?
That was it so far, just the fatigue and the loss of taste. Which is the reason why I was told that I had to take the test. Which I was told at that time also that the earliest my results would be back would be Friday.
And you said at this point you're not willing to take a rapid test.
Well, they said this is the test that they do. The nurse was very clear in what he was telling me when he told me how the test, because like I said, there was a lieutenant and 2 officers right there while the whole thing was going on.
I understand all of that. I have a
And
very
I was-
specific question to
I
you,
was
sir,
asking
though.
them questions, and he specifically told me that this jail, this is the test that they do. They do not do rapid tests. I didn't even ask about the test because I know nothing about the test. This is what I was told. And after he told me that, I said, okay, fine, just do the test and I'll just sit on the protocol. Because at first, when he told me, you're going to have to be on a protocol where you're isolated. I said, okay, fine, just do the test. I'd rather you do the test and make sure that I'm healthy than to just refuse the test and just say, I'll just wait to see if I get better or something like that. So I said, yeah, just go ahead. And that's what I was informed. Friday would be the earliest that I would get the results back. And I would be placed on a protocol, which is called isolation, where I'm not allowed out of my cell.
All right. Found your email in the spam folder.
Anything else, sir, you think I need to know about this issue as I consider your request?
Now, at this time, I'm just telling you what I know. Multiple officers were there. They can tell you the same thing that I'm telling you now. Like I said, Lieutenant Chamberlain was there. 2 officers were there.
Any objection if I talk to any of them to confirm what you're saying?
Absolutely not.
Any objection if I need to ask the jail administrator about, or anyone else at the jail about the protocols and what's available for testing?
Absolutely not.
This is impressive since he objects to everything else.
Given any information about whether anyone else in the facility is experiencing COVID right now?
I wouldn't know that. I wouldn't know who. I'm in the mental health medical pod as it is. I'm
So no information's been provided to you that there's like either a lockdown or some type of a restriction due to any like concern over COVID at this time?
I would never have that information because, like I said, I'm limited in the pod that I'm in. I don't
I'm
have
sure
no
plenty of
interaction with
people in
any
the
other
jail have
inmates,
been exposed.
and my interaction with staff is pretty limited.
All right, thank you. I appreciate that additional information.
It's kind of a breeding ground.
I know, sir, what I've provided to you is generally the for employees. I fully recognize that the jail may have different protocols just because of it being in a correctional facility, and inmates are, of course, or can be very close to one another. And so I don't want to presume that this is exactly what they follow. And so I'd like for them to tell me what their protocols are as I consider this request. At the moment, I told you this earlier, you're not within 6 feet of anyone else in this courtroom. And I believe that provides ample protection for the other people in this courtroom.
I'm sure his former lawyers
as I
are
consider this
ecstatic that they were
request.
fired.
You've provided information to the court. You've been able to tell me the symptoms that you are reporting, your understanding
course,
of the protocols.
If she were to
and
reappoint the
despite
lawyers,
you,
now would be the time to do it.
reporting fatigue. I know, I don't know if you're standing or sitting on the chair. I can't quite tell. It appears like you're standing, but maybe leaning over the table. Oh, knee on the chair. Okay, but you've been able to very clearly, coherently make your position known to the court at this time, and I appreciate that. Let me ask Attorney Opper if there's anything you would want to provide or state at this time regarding this request.
Yes, Your Honor, a couple of things. Number one, we believe this is nothing more than a further delay tactic by Mr. Brooks.
Bingo.
I can advise the court as an officer of the court and as an offer of proof that he is.
How could
Mr.
that?
Brooks,
how
did
could
you
that
hear
even-
Attorney Opper interrupt you when you were talking?
Well, I respectfully object to
You
that.
can object, your objection's noted, but you need to let her state what she needs to state. I will give you an opportunity to respond. I'd
That's
encourage you to use
That is
paper and a
ridiculous, Your
pen
Honor.
to write
In the
down.
US,
That's the
there
rules of
really
the
is
quorum
no
in the
difference.
courtroom, sir. We generally avoid interrupting one another so that, number one, the record can be clear, and perhaps most importantly, because that is a sign that we all understand
And
that this is a place of dignity. It is
motions
a place of
to
respect.
fire an attorney
It demonstrates
or
that,
motions for
frankly,
withdrawal
a willingness on the participants
can get
to
complicated.
conduct themselves appropriately. It avoids
Generally,
creating disorder
if the
or
lawyer
disruption.
wants to quit
So
on
I
the
will
eve
give
of
you an
trial,
opportunity to respond.
a
but you
judge
need
will
to give
deny the
Attorney
motion and
Opper an
force them to
opportunity
stay
without
on.
interruption.
If the
Go ahead,
client
Attorney
wants to
Opper.
fire them,
Thank you, Your Honor. Your Honor, again, we believe this is a delay tactic in line with the
they'll
defendant's
try
behavior
to
since
accommodate it.
about the August 25th or 26th motion hearing. I can advise the court, as an officer of the court, that Mr. Brooks has been saying for the last several weeks in his recorded jail calls to his mother and others that he's going to get this trial delayed or
Good old
adjourned or
recorded
pushed back.
calls.
This behavior, again, on the 11th hour is 100% consistent with that. I believe that if the court wanted more information from the jail administrator, she is present and could provide that information. I believe Mr. Brooks has waived any HIPAA privacy rights he may have in that regard and indicated that to the court. And also, I believe she would be able to provide information if the court ordered her to do so. I believe that even if he is on COVID protocol, it will have zero impact on his ability to prepare for this case. As we've learned already, and I'm prepared to make a further record, he has all of his discovery materials within the confines of his jail cell.
It's a good thing I'm not
He has
monetized,
a
so I don't
tablet
have to
made
worry
available
about
to him in the
the
confines of his
attorneys
own
and
jail
defendant
cell,
using
and he has the
words
ability
YouTube
to use a conference
doesn't
room
like
in his
for
pod.
monetization.
I don't believe the COVID protocol would interfere with his ability to access that conference room whatsoever. But again, I could verify that with the jail administrator if the court thinks that's an appropriate fact. The fact that he claims to have started reporting symptoms as far back as the weekend, we're probably right up against the 5 days right now. If he started this on Saturday, which I don't believe there's any record of,
There's a
we're at
reason he
5
brought
days
it
right
up
now.
today
And
instead
certainly
of
the court's
Monday.
offer to
I never once said,
Mr. Brooks,
I never
have
said,
an
I never,
opportunity
no,
momentarily.
no,
You
I
need to stay
respectfully
quiet.
object to that because that has no merit.
There's nothing
Mr.
respectful
Brooks,
about
it's
what
not
he's
your
doing.
time
No,
to speak.
no, I respectfully object. I never reported saying what day. I never said a day. And if you saying she's saying she has jail phone calls, well, why aren't they present? Why can't they be verified by sworn affidavit and brought into this court to be shown that this is a delay tactic?
The lawyer
as you say
doesn't
it is?
need
How
a
come it can't
sworn
be shown by
affidavit.
sworn affidavit?
She's an officer of the court,
Can you provide
and
proof
her
of that?
saying
All right, Mr.
what
Brooks,
she
I've given you a
has
little bit
Just
of
like-
leeway
just like you're
because we
saying
are outside the
that I've
presence
waived
of the
something,
jury.
Is good
I
enough.
haven't given consent to waive anything. I've simply told the judge that I had no issue with her verifying with the jail that this protocol is in effect and that I was in effect tested for COVID-19. How could that be a delay tactic?
in effect
If
tested.
that was a delay
What
tactic,
does
why
that
would I
mean?
even need to be tested and placed on the protocol? Why does everybody have to have on masks to bring me down here?
All right, Mr.
Is
Brooks,
there no-
I've
is there
given
no
Mr.
verification?
Brooks, I'm going to warn you now that you have interrupted a couple of times.
People are still wearing
You've
masks.
interrupted
Bring
Attorney
him down
Albert
there
I have to
because
be
twice.
able to
people are
speak
still
up.
You're now
catching the
interrupting me
plague.
yet again.
For instance,
I
me.
We all were polite and had you
That
provide
was not
information.
polite. That was
That's
abuse.
the
That
least
was
of your
abuse.
interruption of this court.
That was abuse by the prosecution. That was abuse.
Mr. Brooks, let me finish.
No, because that's
So now he's outright refusing
Running
to
a
listen.
parade
He's
down,
outright
a parade
talking
crowd
over me
down
at the
with a
moment.
truck is
Mr.
abuse.
Brooks, we are at the
I'm
point
not gonna
yet
I'm
again
not
where
gonna
I
sit
will put you in the other courtroom because
and
you
I
are
don't
not
consent. I don't
able.
consent to being removed. I have not waived the right to be present. and I don't agree with that.
your behavior
Mr.
is
Brooks.
de
Does it-
facto
does the
I have
waiving your
provided
right.
you on multiple occasions and it's should be in
And-
front of you.
No,
And
I
if
don't.
not,
I don't acknowledge that. I haven't agreed
you
to
have been
it, and I
advised
haven't
on
given
multiple
consent of it.
occasions that you need to abide by the standards of courtesy and decorum for the courts of Wisconsin. Because you are a litigant, you're both a named defendant, you are now acting as your own attorney by
I'm not a named
representing
defendant. I don't
yourself.
During
recognize
jury
the name
selection the
all
last
of
2
the
days,
Rules
states
of courtesy and
put on
decorum
their
apply
complaint.
to
judge
I don't
you.
recognize that name.
put him in the
That is not
Supreme
who I
Court
am.
Rule
next courtroom over on a
62.02,
video feed and muted
details
him.
many of the requirements for courtesy and
prosecution,
decorum. I've referenced a
though,
couple of them on
asked for him to be
multiple occasions,
gagged.
including that
Which
sub 1 sub F of 62.02
is allowed for
that
disruptive
proper conduct
defendants.
and attire
Makes
is
it hard if
expected
you're
within the
representing
courthouse
yourself.
and, where possible, individuals, including yourself, right, are to refrain from creating disorder and disruption.
He's really going
Sub
to
H, you're supposed
regret
to conduct
going
yourself in a
pro
manner
se,
which demonstrates
or
sensitivity
I should
to the
say
necessity of
pro-per.
preserving decorum and integrity of the judicial process. You have been advised multiple times, sir, of the expectation that this court has that you conduct yourself
I understand
in a
why it
civil
wasn't,
manner.
but
You've been advised
I
multiple
really would have
times
loved
that
to
this
have the
court will
jury
not
selection
tolerate
streamed.
disruptions, interruptions, that when you
It
do
would
that,
be inappropriate
you run
to
the
call it
risk of
entertaining,
forfeiting your right to be
but it
present
would have
in
been
the
a
courtroom.
spectacle to see.
As you know, I have available the courtroom next door that's connected to the holding area. It is connected by audio and visual
Last November,
means. It provides you an opportunity
he's accused
to
he's accused
meaningfully
of
participate
at
by
the
also giving the
Waukesha,
court the
Wisconsin
opportunity
Christmas
to,
parade. He's accused of
control the decorum,
running
to
into the crowd
control the
with his
disruptive
truck,
behavior, because primarily
and
disruptive behavior is
witnesses
repeated
say
interruptions of this court, talking over
he never
this court, now
attempted to
talking
stop.
over the prosecutor.
He
I appreciate
weaved
that
through
you
the
have not
crowd,
interrupted me
but
for
the
quite some
weaving
time.
appeared to be
So
trying to
at this
avoid
point, though, I need
cars
to warn
so
you
that he'd
that
only hit
further
people.
interruptions
So he's charged
may very well
of
result in
6
you being
murders
removed to the other courtroom where
and
you would
about
participate by
60 or
audio-visual
70
means.
counts of
At
grievous
this
bodily
time,
harm.
I would like to hear from the court administrator, especially as it relates to the protocol.
And in Wisconsin, they have no
Did I
death
say the court
penalty.
administrator?
So he's
That's all right.
facing
That's okay.
6
We're
life
in court,
sentences
and
plus
I would like to hear from the jail
about
administrator. Thank you very
500
much.
years of
And
additional
just to get some
time.
general information, and perhaps even some specific
a
information
real monster,
regarding
basically.
what Mr. Brooks has provided, since he indicated I could verify all of this information with either the lieutenant or others who were present. So
It
I
was a
believe we
Christmas
have,
crowd.
Angela Wallenhopt here, if she would come up to the
It
witness
was a
stand.
Christmas parade.
Your Honor, and if I don't want to mix issues, but the inmate communication form from September 28th.
And when he
also
fired his
still needs
attorney
to be
last
addressed
week,
by the court, and I think
he did
the
say he's
jail
doing it
administrator may
because
have
he's a
some
sovereign
information relevant to
citizen.
that issue as well.
All right, thank you. I
Please.
have a list of a bunch of things I want to go over, and I'm gonna,
So, Your Honor, strictly just so I'm clear, are we addressing the issue at hand now,
we are.
or are we addressing something from September?
Well, I will get to the September inmate communication form at some point during this hearing, but right now I'm addressing the most recent inmate communication form that is dated October 5, and that addresses your request for an adjournment. So I'll have you sworn in. I'll just do it. Raise your right hand. Do you solemnly swear that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Would you please state your first and last names for the record?
Angela Wallenhop,
Would you spell your last name?
Wollenhaupt.
Thank you. If you could please advise us on the record again of your job title and responsibilities.
I'm the jail administrator for the Waukesha County Sheriff's Department. I am head of the division in charge of all staff and inmate issues.
Could you provide information to the court on the general COVID protocol within the jail?
Judge, I would prefer to not speak to the operational considerations with that. I can speak to the fact that there are different protocols that are put on people for different medical or management reasons, which may have modifications to them. I can speak to the protocol Mr. Brooks has placed on, that it won't affect the area he is living in, nor access to areas that are not other inmate occupied.
That seems fair. I don't want to certainly put
That was
all of your
nice and
operations
vague.
on display. That's not necessary. But if you could speak to the specifics as it relates to Mr. Brooks's current situation.
So he would remain in his current cell housing location. He would have access to a conference room if he needed it, access to a telephone. And we would be able to, it's a safety security measure for him as well as our staff. And we can safely produce him for court.
When I hear the phrase being on a protocol, that to me could have more than one reason. Someone could have been exposed, someone could have tested, or someone could have reported symptoms that required testing. Would I be mistaken in any of those beliefs?
You are correct, Judge.
Would there be any other reasons for someone to be placed on a protocol, a COVID-19 protocol within the Waukesha County Jail?
No.
And would you tell me which one of those three options has prompted the COVID protocol for Mr. Brooks?
Judge, I have not reviewed his medical record prior to arriving here.
All right, fair enough. Do you have an understanding of what that is
Yes,
based
however,
on information provided to you?
yes, however, he has not signed a release allowing me to speak to the court. So if you are ordering me to speak to the court, I can speak to what my understanding is.
Mr. Brooks, I took your statements earlier that you would not object to me asking jail staff about the current situation to verify the information you provided. Is that still correct?
I said that I wouldn't have any issue with pertaining to myself. I don't know. I'm not speaking about anybody
Just
else in
answer
the
her
jail.
question
I'm not speaking
directly.
about what everybody's situation is different.
Right. And I'm specifically referring to your situation.
Well, the question was asked in how does it pertain to me? It was pertaining to me, all the questions, which it came up when I said that there was a lieutenant and there were officers present when I took this test from the nurse.
Right. I'd like to verify the information that you're providing to me regarding what was reported by you, what tests were administered, and why you're on the protocol with the jail administrator. First of all, do you understand what I want to ask her about?
No, I do not understand.
Did you hear what I said just now?
I do not understand.
But did you hear what I said?
Frankly, Your Honor, I think she would probably be the wrong person.
By this
to be
point, the
asking
judge
that if she
should
wasn't present.
You must
understand
understand then what I'm saying if you
that
think
she
she's
should
not the
ask him,
person who
"Do
would
you
provide that
comprehend?"
information. So,
I do
instead of
think she was
understand.
understanding or agreeing to that. No, I do not understand.
all right. I took his statements earlier. I realize you don't have a written waiver as to be a verbal waiver of any privacy rights under HIPAA, and I am directing you to answer the question.
It was brought to my attention shortly before the lunch hour that he had made statements that prompted the medical department to follow up. As I said before, I have not reviewed the medical record. It is my understanding he was administered a test. He was also offered another test, to which he refused.
Do you have any information regarding whether this other test would have been a rapid test?
I believe it to be.
Do you have those tests available in
So,
the facility
basically,
to offer to an individual?
as the
I have
prosecutor
one
said,
available right now.
this is a delay tactic. He wants a 3-day test instead of a rapid test
Can I ask a question?
so that he can delay the
Of
trial
the
until at
witness?
least next week.
Jail administration.
Go ahead, you can ask a question.
Ms. Wallenhoff, if there were different types of tests available, why wasn't I administered the correct test when I first was tested? Why would essentially I would be asked to take a test, take that test, then turn around again and be told to take a whole nother test? In my mind, that's almost like some type of ploy or something, some type of scheme. Why
Sir,
He knows all about
I asked the
crazy
question, why would I
ploys
not
and schemes.
be given the correct test from the get-go instead of having to take 2 tests? If I've already taken
Mr.
one
Brooks,
test,
you have to give her an opportunity to answer,
If
and you
I've
gotta
already-
ask one question at a time.
I just asked the question.
Playing
Did she answer that?
semantics games
Do you want her to answer it?
really doesn't
I
work.
presume you do, since you asked the question, so you need to stop talking so that she can answer
And
it, okay?
from my observations,
Immature abuse, Your
this
Honor.
guy isn't smart
sorry?
enough to play the
I don't
semantics games.
Appreciate being talked to that way, Your Honor.
Your objection is noted. Go ahead and answer.
Judge, I would prefer not to answer that question. He states the wrong
He's
test.
been
I don't know
abusive
what
for
he's speaking
days,
of. I have not reviewed the medical
but
record
objects to
with
being
what test
talked
was
to
administered, so I
that
would prefer not to
way.
answer that question.
All right, fair enough.
I did not say the wrong test. I said 2 tests. If it was, why would I need to take 2 tests for the same symptom?
Your Honor, I object to relevance and beyond the scope of this witness's knowledge, and it also assumes a fact, not an evidence.
All right, so I'll sustain the objection. I'll give both parties an opportunity to ask questions of this witness since it's Mr. Brooks's request. I know do you have any other questions for Jail Administrator Wallenhopt on this issue at this time?
I don't think I was clear. Or I didn't have
Semantics will also lead
clarity
to him
on
being in the
the
next
answer to
door
that question.
courtroom.
Essentially, what I'm asking is,
It's going to be real hard to
why
object
would I need to
during
take
the
2
trial if
tests
he's
for the
not in
same
there.
thing? There shouldn't. If I'm taking a COVID test, why would I need to take another one?
And I'm gonna object as to lack of foundation and beyond the scope of this witness's knowledge, Your Honor.
You're
The
going to be
objection is
taking those tests
sustained.
until
I'll
you
direct the
have a
witness.
negative
She does not need
test.
to answer that question. Next question, if you have one, please.
I still don't have clarity on that, Your Honor. I'm baffled.
Do you have another question? A different question?
Would it be any way
Psychobabble is a
to
good word for it,
verify
with a P or an
why
S.
I would need to take 2 tests for the same symptoms?
I'm not sure I understand the question, sir. I think
I'm referring to the nurse who administered the test.
the nurse isn't here, though. This is Jail Administrator Wallenhopt.
The real question
That's
is,
why it's
why
hard
is he
for me
so
to
hung up
wrap
on
my head
this?
around
Just
why
take the second
Ms.
test.
Wallenhoff would be called
Simple.
to testify when she was not present. I think the wrong person is testifying.
Do you have any other
Because
questions
the
for
reason
her?
why I
I
say
understand
that-
what you're saying. Do you have any other questions for her, though?
Are you sure you wrapping your head around what I'm saying, Your Honor?
Do you have any other
Almost
questions
like
for this
they
witness?
weren't expecting this to be an
To
issue,
your knowledge.
so they didn't have the nurse present to testify.
You just said that you have a rapid test available right
But
now.
what
When
do
did
I
that
know?
become available? Because I was told otherwise.
I know there is a rapid test available right now. As I stated before, it is my understanding that you were offered a rapid test and you refused.
So why was I not offered a rapid test from the get-go?
Objection, relevance.
If she knows, she may answer.
I do not know the answer to that. I have not reviewed the medical record, jail contracts with the medical provider.
Thank you. Next question, if you have one.
So there,
It's going to
there
be
are
the
more
exact
than
same question
one
again.
type of COVID test administered by this jail.
Again, the jail contracts, Judge, I prefer not to answer that. The jail contracts with a medical provider. I do not direct testing for medical conditions. That would be our medical contract.
I believe the record's clear that a rapid test was offered. It was declined by Mr. Brooks. The record's also clear that
I
he did
object to that,
submit.
Your Honor.
He did submit to a test, but this witness is not able to answer whether that was a rapid or not, given her
He's tried everything
role
else by now.
in the Waukesha County Jail as the administrator and not in charge of medical. I will find she does not
I
need
think
to answer
tomorrow
that
he might
question,
actually bring a
because it's
kitchen
outside
sink
her
for his
scope.
opening arguments.
And to further answer it might be speculative. So do you have another question?
So would it be fair to say, you just said it would be speculative, so would it be fair to say that it'd be speculative that the second test would be a rapid test?
I can't
I will
believe
make
they've spent
a determination on your motion.
45
after all of the
minutes
evidence and testimony on this
discussing
issue is received.
testing.
Is
Uh,
that an
I
answer,
can't
Your Honor?
answer that question at this
Well,
time,
I'm
sir.
asking it of Ms. Wallenhoff.
I'm sure there are so many other
Because we just said it would be
relevant
speculative.
and
They were
much more
looking at me
important
when you said
issues.
that,
Well,
so are you?
I'm-
And
and
I'm
yet
not going to answer
They've
that
spent
question.
45
I'm
minutes
not a witness in
about
this.
The
testing.
I
reason
make
why
the
I was-
determination
reason why I was
ultimately.
looking at Your Honor is because
Do you have another question
I'm
for
still trying to
Jail
figure out
Administrator
how-
Wallenhaupt?
I thought testimony was
Thank you.
supposed to be
I get a
the
little sarcastic
prosecution
sometimes,
the
and
defense's
some people don't like it, but
time to
I
to
do.
ask
Do you
questions.
have another question? Otherwise, I'm going to ask the state if they have any more for this witness.
I asked the question, would it be fair to say that it's speculative about what the second test actually was?
hopefully
Mr. Brooks, I don't understand.
it's
your
not the
question.
one that the jail was
What isn't to
thirsting
understand about it?
Deborah Rogers with.
If you were
I
were
assume you've
offered a
been
test-
following the Delete Laws saga
No,
on
it's-
other
it's a
channels.
question.
Hold on.
I'm
You're
getting
asking
some-
a
I'm going
hypo-
somewhere.
I'll let you get the question out, but I would just note you're asking her a hypothetical that, given her role, she might not be qualified to answer. But you can go ahead and ask it.
Well, it's not hypothetical. It's very logical. If you were offered a test and you took it, why would you
Hypothetical
need to
and
essentially take
logical
another
are
test
not
that could have been
antonyms.
done right from the beginning? If there would be any issues, if there would be
Right, Mr. Brooks, it's not relevant what she would do. So that's essentially an argumentative
Okay, so
question,
why-
and it's
so why would I
not
do it?
relevant. So
why would
sit
I
down.
do it then?
You're done asking questions because you've
So
now
is that a
asked.
judicial determination?
I haven't made a judicial determination yet.
You're
Go ahead,
practicing
Attorney
law from the
Opper.
bench by being able to ask
Mr.
certain questions
Brooks?
of yourself.
Mr. Brooks, okay, here's your warning. I'm giving Attorney Opper an opportunity
So
to
you're
ask this
practicing law from
witness
the bench.
questions, and if you interrupt her, you will be removed.
I
to
did
the
my
next courtroom.
I
master's
don't
degree in
consent to,
England.
being removed to the next courtroom.
and
I don't consent to even
the
being at these
English
proceedings if I'm not
tend
able
to be
put on a
brutally
proper defense, which is
sarcastic,
my constitutional right to
they'll
be able to do so.
just
I haven't agreed to any contracts.
mercilessly rip into
consented
each
to
other.
any contracts, and I have
Your
not
objection
consented-
is noted. Attorney Opper,
But
go
it's
ahead.
I have not consented.
Understood that it's in
Ms.
good
Wallenhout.
fun. So my guitar teacher
Although
here in
Mr.
Utah,
Brooks is under a
is
COVID
from England,
protocol,
and so I
is
was
he
one of his
still allowed to
favorite
review his
students
discovery materials in his jail cell?
because
Yes.
Jay Farrell is
To
the
your
city.
he could
knowledge,
rip
do
into
those-
me
are those
like that,
materials-
The objection.
knowing that I
I'm
wouldn't
sorry.
take offense.
To your knowledge, if you know, are his discovery materials currently in his jail cell?
Yes, ma'am, to the best of my knowledge.
I haven't covered the Delete Laws saga
Is he
because
I
still
object
able?
to that, Your Honor.
the truth is I find
I'm,
him
I'm not allowed
Sir,
to
her
keep.
an
answer stands. There's
uninteresting
no question to which to
bore,
object.
I object to
basically.
that. There is.
But the other
She can't
channels,
testify at the moment.
covering
If you want to
him
provide
like
further information
Blue
after
Bacon
she
and
is done testifying,
Masshole
I will give you that
Report,
opportunity.
Will she,
Their
will she be
Objection
able-
coverage
is
will she
overruled.
be able to
is
stay right there so I can
interesting.
ask the question?
It's not your time yet. You have to wait. So this is the final warning. Okay, I've given you a lot of leeway today.
You have not, Your Honor. You haven't. No.
I
you
am
haven't.
turning to Attorney Opper. It
She's
is
given him
her
all the
opportunity,
leeway.
her turn
I'd be in jail for contempt
to
by now
ask
if I
this
acted like
witness a
this in
question.
court.
And it is my right to be able to object, just like she objected
And-
when I was asking
Right,
questions.
and when the court rules on an objection, usually the party who objects stays silent. I rule on the objection.
And then it's
The
done.
parties don't debate the ruling. It's noted for appeal. And then we move on.
Then I would like to put you on notice that I will be appealing that judicial decision that you are making.
Next question.
And the
Attorney Opper.
appeals court
The judicial
will laugh
determination.
Swollen
and
hot.
laugh and
While
laugh.
on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses. Is that correct?
Yes, ma'am.
And while he is on COVID protocol,
he
does
can be
have
prepared.
access to the conference room, which also contains a computer
Not that it
with
matters to
further
him
legal
because
materials?
Yes, ma'am.
And nothing about the
he
protocol would
complains
restrict
about it,
his
but he
access to
hasn't
any of those
taken
materials.
advantage
Is that
of
correct?
what the jail has
Correct.
made available to
And
him.
you've
I object to
indicated
that. I
previously.
object to that respectfully, Your Honor.
So an objection goes to whether there's lots of rules of evidence that apply. But if you're objecting to her answer, that's a different thing. You can argue the meaning
objecting
of
to
that
the
later.
question,
Okay,
not
the
the
objection,
answer.
but then you have to say objection before she answers. You
She
objected
didn't
after
answer.
she
She
answered.
didn't answer the last
The
question.
objection is noted, it's overruled, her answer may stand. Next question.
Ms. Wollenhop, you're aware that there has been digital discovery made available to Mr. Brooks for him to view in the Waukesha County Jail.
There
correct?
are
Respectfully object to
problems
that.
with the
Overruled.
American justice system.
He would view that digital discovery on the computer in the conference room in his pod,
I
correct?
respectfully object
Those
to that.
problems haven't been on display
Overruled.
in this
You may
case.
answer.
Correct, ma'am.
And
So you're gonna
the proto-
overrule everything, Your Honor?
He has been given
All right,
every
Mr. Brooks.
opportunity.
You have got to stop.
He had
It's fine if you object. I
two
will rule on it as I deem appropriate. under
very
the rules of
experienced
evidence,
attorneys
Which, by the
who
way,
have
I
spent
provided
almost a
copy for
year
you. See that
preparing
big
for
book
this
over
case.
there?
No, I don't
It
see
has
it.
the criminal
I
statutes.
don't see
It has the traffic
yet
code. It
he's
has the rules of
still
evidence. Well,
given
it's
the
on your
chance
table. It's
to represent
behind the
himself.
microphone, and it's there. I've provided it to you as a courtesy so that you have that available to you.
Anything to me.
All right, I'm
Something
directing the
that-
bailiffs to
something
remove
that
him
may
to the
have-
other courtroom.
something
I've
that-
provided ample
I've
opportunity for
never-
Mr.
I've never
Brooks to
taken
abide by the
anything-
simple
I've
rules
never
of
taken
decorum
anything,
and
Your Honor.
civility.
Your Honor, I don't
He is-
consent or agree to what you are doing.
Your lack of
don't give
consent is
consent.
noted for the
I
record.
don't give
And
consent
your
to a
consent is
estoppel. I
not
don't-
I'll make
needed.
a more full record when we
I
are
don't give
open
consent
again to
a
the public.
estoppel. I don't give consent to be removed.
Madam
from
Reporter,
being
the
able
record
to
should
exercise
reflect,
my
the court is
constitutional
stepping
right.
off the bench. You may step off.
I
if you
move,
want.
I move for a motion.
There
to
are
dismiss.
many
You
where he
still
would
haven't
have
even ruled
been.
on the claim. There's no one that even has a claim against me here.
Well, that was exciting. We'll see what happens when court comes back after he's been removed. I didn't catch what the judge said right there at the end, how long this recess is going to be. But the last 2 days during jury selection, he was removed several times. And by several, I mean he spent more time in the other courtroom than in this one. And he was muted. He spent much of his time I assume he was yelling and screaming. It looked like it, but he was muted. He spent other time reading the Bible at the council table. And he when he was in the courtroom, when people could hear him, um he he deserves court. It's obvious that he did it. There's no question as to identity or what happened. But there is still a question as to what he's guilty of. He he did earlier have he was going to go for the insanity defense. That was withdrawn, I think, in September. But I think the big thing that the court is going to try to prove is, well, I say court, I meant prosecution, um, is intent. Did he intend to drive through all those people, or was it an accident? So that's the difference between a murder conviction and manslaughter. And I think, given the circumstances, even being convicted of manslaughter could be essentially a life sentence in this case, because just based on, oop, sorry, just based on the totality, I could see him receiving consecutive sentences for manslaughter, which I think in most cases wouldn't happen as much. Just because if you don't intend your actions, it, it's it doesn't make as much sense. But due to his outburst and just poor behavior overall over the last year in court, I could see him receiving consecutive sentences for manslaughter. If Wisconsin had capital punishment, a trial would definitely be needed, even if he had admitted to murder. I think you're right on, especially in a case like this, a trial can be traumatizing for the victims, but it can also bring closure, which is why after someone's been convicted at sentencing, the victims are given a lot of time to say whatever they want. And they say things that in most cases, in most situations, would really be contempt of court. But it's viewed as such an important part of the court case, of the justice system, that people are given this chance. But testifying in the trial is also important for the victims. And so while I think in some cases the gut instinct is to say, "Oh, there's no need for a trial, just lock him up, throw away the key." But I think to give the victims, and when I say victims, the witnesses of this event who maybe weren't physically injured, and so there's no charge for injuring them, they're still every bit the victim. And it can give them closure to testify. And this is a problem. Uh, I mean, Mr. Brooks definitely needs to be locked up, but there are so many people in prison that don't need to be locked up. And unfortunately, the jails and prisons are criminal university, essentially. And so people are locked up for, say, having an ounce of weed. They're not a bad person, but they might come out a bad person. And that's unfortunate. It's and really saying unfortunate, that is an understatement. It's a tragedy. And in the US, there's just too much money to be made in locking people up. If if I were in charge, I'd ban private prisons because there are things that shouldn't have a profit motive. And this is very true. A former neighbor of mine got a slap on the wrist for doing that to his child. And I know people who spent quite a while in jail for underage possession of alcohol, which is insane. It's there's no other word for it. It's just insane. And I'm kind of a funny person, not haha funny, but as a lawyer, I've primarily worked in criminal defense. I've never worked as a prosecutor, but I have applied for prosecutor jobs. And there are a lot of people that would only do criminal defense because they're all for helping people and keeping them out of jail. And there are other people that would only work for a prosecutor because all criminals deserve to be hung, drawn, and quartered, and there's no in between. Whereas I view them both as prosecutor and defense as very close because you need people in both jobs that can see it from both perspectives. You need prosecutors who have empathy for the defendant. You can't view them as the enemy. You have to view them as people who need help, and sometimes jail is that help that they need. But as a defense attorney, you also have to understand some people need jail, but it's your job to make sure the state proves their case and that the defendant receives due process. And I definitely agree with you on this. I, in working criminal defense, I have refused not just this crime, the SA, but I on a child, but any sex crimes really. I I'd have no problem defending a murderer, which isn't to say I'd like the client, and I haven't defended one yet, but I I would. But the reason I wouldn't do these crimes is because I wouldn't be able to cross-examine the victim. Because there are questions that, in the zealous defense of your client, you would have to ask the victim, which would not only be traumatizing for the victim, but it would traumatize me. And so I just couldn't cross-examine these victims. That's true. The neighbor who did it, who received a slap on the wrist, I have occasional interaction with his victim. My mom actually has more interaction with her, and she has spoken about the difficulty of forgiveness. In speaking about the difficulty of forgiveness, she didn't specifically mention her dad, as I understand it, but it was understood that's what she was talking about. And I just can't imagine the strength that would take. I'm I do try to be a forgiving person. I don't think I would be strong enough to forgive this. I'm lucky that I never have had to forgive this, but it, it it's just awful. And it looks like since the since kicking the defendant out of the courtroom, it looks like the hearing must be over. Let's see. The I believe the live stream has officially ended. The Law and Crime live stream. Gonna check. Oh, they actually do have a part 2 up now, which means this
Undone.
won't be live. Quite.
Thank you.
I'll rewind it. Rewind being quite an anachronism of, but I'm old. Let me see. All right, let's see if it.
All right, before we continue, the record should reflect that, and at the moment, Mr. Brooks is
All right,
muted, so
there
I
we
can
are.
properly make my record here today. I will promise to unmute him when we continue with the hearing after I make my record regarding the removal, assuming he can maintain even the simplest of civility and
The
not
previous
interrupt other
hearings have all
individuals,
been
in
broadcast
a way
through
that is
Zoom,
disruptive and
but this morning, Court
Uh,
TV spent hours setting up cameras in the
And I do
courtroom.
want to initially confirm.
I don't know if they
I
set
know
one up
I
in
could
the
hear him
other courtroom,
until I muted him. I can
so we
see
might
him.
not see him in
Could
there.
we please get confirmation from the other courtroom that the audio and visual is working? All right, and we do have confirmation of that as well.
Oh, looks like they
Prior
did,
to
but that might be through Zoom
the court
anyway.
ordering Mr. Brooks removed from this courtroom to the neighboring courtroom, there were 9 interruptions. So it was on the 10th that this court ordered him to be removed to appear remotely from that other courtroom.
I'm kind of impressed she counted.
I have cited repeatedly from Illinois versus Allen, which is the Supreme Court case from 1970, which provides this court with the authority to remove Mr. Brooks from the courtroom. Because it is a new day, I think it bears repeating much of the language that is directly on point in this decision.
She
It is
really
essential to
doesn't
the
want
proper
this to
administration of
be
criminal
overturned
justice
on appeal.
that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. This is the Supreme Court stating, "We believe trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. We think there are at least 3 constitutionally permissible ways for a trial judge to handle an can't say that word all the time,
Obstreperous.
defendant like Mr. Brooks. In that case, they were talking about the defendant, Mr. Allen. And here are the 3 options, at least that the Supreme Court acknowledged. But I would note, as they just said in this prior quote, there are at least 3. 1, bind and gag, thereby keeping the defendant present. 2, cite the defendant for contempt. 3, take him out of the courtroom until he promises to conduct himself properly. This court has repeatedly utilized the neighboring courtroom because I believe that provides Mr. Brooks with an opportunity to meaningfully participate in these proceedings while this court maintains decorum, dignity, and respect. It is an elementary
The
standard of
Illinois
proper
versus
conduct
Allen
to
case is
not
from
interrupt.
1970. So
Mr. Brooks
it was deemed appropriate to
repeatedly
remove
interrupts.
the defendant from the courtroom
I
even
gave him
before
9
video technology
before
would have given
I
him the
removed
opportunity to still
to the other courtroom.
participate.
As the court did in Allen, this court decided that under the circumstances,
holding his
to remove
objection
Mr.
sign
Brooks from the courtroom
Reminds me
and
of
to continue
Judge
the trial in his
Middleton
absence
holding his
until
unmute
and unless
yourself
he promised to conduct himself in a
sign.
manner befitting an American courtroom, that this is the proper response to his conduct. As noted in the Allen decision, the court stated, "We find nothing unconstitutional about this procedure." This is now the 3rd day of the trial. We struggled at times through jury selection with multiple interruptions, what I would describe as disruptions. So it's with that history we came into court today. Mr. Brooks persists in his unruly conduct.
Judge Middleton is what
I would note,
judges
just as the
should
court
be.
in Allen did, it is not pleasant to hold or to find that Mr. Brooks be banished from this courtroom
He really is.
as part of his
what
own
all
trial
judges
to the
should be.
neighboring courtroom. And this is what the Supreme Court went on to say, but our courts, palladiums of liberty as they are, cannot be treated disrespectfully with impunity, nor can the accused be permitted by his disruptive conduct indefinitely to avoid being tried on the charges brought against him. It would degrade our country and our judicial system
The
to
jury
permit our courts
is going to
be
hate
bullied,
his obstructive
insulted, and
conduct.
humiliated. And
they are
orderly
going to hold it
progress
against him.
thwarted and obstructed by defendants brought before them charged with crimes. As guardians of the public welfare, our state and federal judicial systems strive to administer equal justice to the rich and the poor, the good and the bad, the native and foreign born of every race, nationality, and religion. Went on to state, but if our courts are to remain what the founders intended, the citadels of justice, their proceedings
Some of the judges
cannot
that get a
and
lot of
must not be
time on
infected
YouTube
with the sort of
annoy me.
scurrilous, abusive language and conduct.
But that's why they get featured on
demonstrated
YouTube, is
by not
because of
only
their
Allen
antics.
In that case, but
Judge
by Mr. Brooks
Middleton.
in this case. I've also cited repeatedly to SCR
Is
Chapter
unique.
62,
He is quirky.
which contains the
But he-
standards of courtesy
has
and
such
decorum
good
for the courts of
decorum.
Wisconsin. I've advised Mr. Brooks
He just
repeatedly.
gets
I've had
Crazy
just as
people
I
in
am
there all the
holding
time.
A copy of Chapter 62 on yellow paper laminated. I have it myself. I provided it to the state.
No, the jury
I
is not in
provided
the
it to
court.
Mr. Brooks.
This is a
And
pretrial.
those standards
hearing.
govern what I do, what the
The-
attorneys do, what lawyers, clerks, court personnel,
The jury
even
will be in for
witnesses,
the
defendants, jurors,
opening
and others appearing in the
statements
court.
tomorrow
Two
morning.
of those subdivisions specifically talk about
I'm sure they won't
the
be shown on
expectation
camera,
that
though.
within the courthouse, that those involved in the proceedings refrain from creating disorder and disruption. Another
I'm surprised
subdivision
that
of
they're going to
section
get to opening
discusses
statements
the
tomorrow.
expectation
I thought it would
that
take all week to choose
those
the
within the
jury.
courts conduct themselves in a manner which demonstrates sensitivity to the necessity of preserving decorum and the integrity of the judicial process. Once again, it did not take Mr. Brooks very long to begin interrupting. It is 2:39 now as I go through this
Didn't take him long to stop.
decision making
or
and put my
Didn't take long to
findings on the
start, and he
record.
never stopped.
But his behavior started very early on. I gave him ample opportunity to abide by the rules of decorum. I gave him
I'm glad to
ample
hear it.
warning
It-
before he was removed. This court, frankly,
It makes
has
it
no
easier having
other
someone to
option
talk
at this
to,
point,
as opposed to
um,
just
other
talking to
than
myself.
to put him in the other courtroom so that I
That
can
just gets
continue with
awkward.
this very important hearing, a hearing at which he has requested an adjournment of the proceedings.
Frankly, that's why I'm so monotone in
With
my
that, I will
pre-recorded
turn back
videos.
to Attorney Opper. I am going to unmute Mr. Brooks, but also advise him that if he interrupts Attorney Opper or others as they are providing testimony here today, I understand he can object. However, my expectation for that objection process would be that he say, I object. He provide a basis. I oftentimes
She
give parties, give me
really
one
doesn't
word.
care
Is
that
it
he's holding that
hearsay? Is
objection
it,
sign.
calls for speculation? Is it irrelevant? Whatever it may be, a very either 1-2 word objection or a very short summary statement of the basis for his objection. After he does that, I will rule on the objection, and I expect him to honor the ruling that I have made. If he can't do any of that, he will remain muted.
He
And
won't.
the process will then be, we've given him a sign. He's holding it up right now, demonstrating for us. He has the objection sign. He will be required to write down his objections on a piece of paper that will be provided to the bailiff. The bailiff will provide it to me, and then I can rule on those, even if it's striking testimony later on. I
They
do
should have given
expect his
him
objections to
specific
be based
objection
in law.
signs.
He, I note, was provided with the copy of, it's a selected statutes, including the rules of evidence. All right, go ahead, Attorney Opper, for the record. The mute has been undone.
Thank you. So Ms. Wollenhop, I was asking you about the digital discovery materials. You testified that you're aware there is a thumb drive available for Mr. Brooks' use that is maintained in his pod, and all he has to do is ask for it, correct?
Correct, ma'am.
And that in order for him to view the contents of the thumb drive, he'd have to use the computer in the conference room, correct?
Correct, ma'am.
And that is available to Mr. Brooks upon his request, correct?
Correct, ma'am.
And nothing
Hold on a
about,
second. Mr. Brooks, the basis for your objection at this time?
That it's irrelevant
He-
to why.
He doesn't agree with what she's saying.
Asking for the attorney based on being able to utilize the conference room or the tablet.
Your objection is noted. It's overruled. Her answers may stand. Next, you may continue, Attorney Opper, with your next question.
the nothing about this protocol then would limit his access to any of his discovery materials, correct, ma'am?
Objection.
Overruled. She may answer. Correct, ma'am.
And he would have access to the telephone if he wants it.
Objection.
Overruled. She may answer.
Yes, ma'am.
And there would be nothing that would restrict his ability to come to court each day?
Objection.
Overruled.
Correct, ma'am.
And when he comes to court each day,
His
he has the ability
histrionics
to bring whatever discovery
aren't
materials with
helping,
him that he
but-
wants. Is that
But
correct?
you have to have a reason
Overruled.
for
Correct,
objecting.
ma'am.
Just not
And
liking
in
the
fact, there's a
question
card
isn't.
available for him to do
a
that
proper
if he
and-
so requests.
It's not a proper
Objection.
objection.
Overruled.
That is correct, ma'am. Correctional officers would transport it, but yes, there's a card available.
Sure. Mr. Brooks had told this court earlier that he started feeling not well, I believe were his words, over the weekend. And is there any notice to any correctional officer or jail supervisor that you're aware of that Mr. Brooks reported that to them?
Objection.
Overruled.
I have not reviewed the jail medical record. This came to my attention shortly before the lunch hour.
Okay, I guess maybe I'm asking
He's
a
going
question
to
I don't know
object
the answer
to
to.
every
If he were
single
to say to one of
question
the officers
over
or
the next
lieutenant,
month.
Hold on a second. Was that an objection?
Of course it
Or
was.
Just a comment under your breath. Your objection's noted. It's overruled.
Like I said, she does not want this to be
if he were to
overturned on
complain of
appeal.
illness to a correctional officer or a lieutenant, would they document that in any way?
They would give him a medical request form to fill out, which would go to the medical department where he could have contact to medical staff, or it could be documented in the jail management system.
To your knowledge, was that done by Mr. Brooks last weekend, the weekend of September 30th and October 1st?
Not to my knowledge.
And are you aware of the fact that last weekend, on or about Saturday, he requested a shower and a shave?
Yes,
Was that provided to him?
yes.
For some reason,
You weren't
this
on a
witness
protocol. Would he still get those things?
just reminded me,
Or does it depend?
It would depend what type of.
and I
protocol.
really don't know why, but she just reminds me kind of the victim
Those were all my questions.
in
Thank you,
the
Ms.
recent
Wallner.
Trevor Summers
Mr. Brooks,
case
Do you have any follow-up
that
questions for
Law Talk with Mike
Ms.
covered,
Wohenhoff?
where the sentencing
I
was
do.
just on Monday.
You stated that it would depend on what type of protocol I was on, would dictate if I'm able to shower, correct?
That was not completely what I stated.
And as a callback to our earlier
So
discussion,
that's what you just stated.
talk about strength
Well,
from a
different
victim.
management protocols,
She
it would be in accordance. with
Really impressed
jail
me when
operations,
Mike
and my preference,
interviewed
Judge, would
her
need to be to
last
speak to all
month.
of the jail operations.
Right, I'm not going to require her to speak to all the jail operations. If you wanted to ask her, for example, whether your current protocol would prohibit that, I think that would be a fair question.
So that would be the question then, well, no, let me ask this, what specific protocols would prohibit being able to shower?
Objection, irrelevant.
I'm not gonna, it's sustained. Mr. Brooks, I'm going to honor the request of the jail administrator not to talk generally about protocols, given the operations of the jail, but you may ask her if there's something specific as to you.
Well, because of my situation
I
being a little.
only
bit
watched from when he
any
started
protocol that I
representing
am on
himself.
currently prohibit me
What a
from being
mess.
able to shower and or shave.
And he really did
Do you
it
speak moving
just
forward?
to try to re-victimize her,
As of
just
right
to
now.
assert power over her
You would
one
be allowed
last
to shower on the
time.
protocol you're currently on.
Just absolutely
Will I be able
despicable.
to shave?
You would be able to shave.
Would that be with the clippers or a razor?
Objection, relevance.
Overruled, she may answer.
This has
Mr. Brooks, we
no
would monitor
bearing
behavior
whatsoever.
and other factors in that and make a
On the
determination.
trial.
There's procedures operationally in the jail that you can request those items. And
So
you
that would
could,
be independent of the COVID protocols.
correct, ma'am.
So to your knowledge, are you aware that we are only permitted, and I'm saying myself as well, being housed in the jail, that we are only permitted razors once a week and clippers only once a month?
Judge, I would prefer not to answer questions in regards to jail operations.
Right. I'll honor the request of the jail administrator.
Is
who is
he
beyond the scope of
worried
this
that
hearing? She need to
having
answer
stubble
general
is going to
questions about the general
impact the
procedures
jury?
and protocols within the Waukesha County Jail.
This is just
We're a
ridiculous
little hard field. I
nonsense,
gave you a little bit of
wasting
leeway.
time,
We had started this off about COVID protocols.
which is
and
basically
your
what the judge is
current
saying now.
situation. So from my perspective, the questions regarding the discovery materials and all of that were relevant because you claimed you weren't being allowed out to a conference room. That to me implicated your ability to prepare for your defense and this trial. So that's why I allowed those questions. Whether you shower or shave would, in my humble opinion, not be relevant to the issue of whether you can assist in your own defense.
Completely irrelevant.
Respectfully,
And the jury's not going to smell them from the other courtroom anyway.
it was brought up about the whole issue of being able, me requesting to be able to shower and shave, so that's why I brought it up in my question.
I understand, and I'm under my authority under 906.11. I'm going to advise both parties that anything regarding those types of things are not relevant, and I won't allow questions from either side regarding that any further, at least today on this particular issue.
Thank you, Your Honor. Would want to make one correction for the record. I never claimed not to be able to have access to certain things. I merely claimed that I am on a protocol which limits me even more than I'm already limited. I made no reference to anything in specific, just the fact that I'm on a protocol which restricts me to my cell until the test can come back.
I appreciate that clarification, sir.
Except
Thank
the
you.
jail administrator has already
Do you have
said
any other
he
questions?
has access
for
to the conference room. He
Wollenhoff?
has access to the telephone. He has access
Okay,
to
go ahead.
computers and a tablet.
Would you care to share with the court on record, the types of protocols that I'm currently
I love how
on
pro
outside
se
of
defendants
the
always
COVID
say,
protocol?
on the record, on the record, on the
Supposed
record.
Jail operations.
Sustained. Next question.
Does my specific protocol change the normal time that I would be allowed out of my cell?
Judge, again, that speaks to jail operations.
Mr. Brooks, unless you have a specific question related to access to your materials, I'm going to have her not answer that.
They really don't
opposed
want
to-
inmates to know how the
That
jail
directly
operates.
Goes to that because, as we know,
Any information
I'm
is
only
going to be
on
used by someone to try and cause
protocol where I'm
trouble.
only allowed out of my cell a few hours a day as it is. Now being restricted to my cell because of the COVID protocol. The question I'm asking is, does that restrict even the time that I can be able to be out to utilize the things that I need? Because essentially, I'm only limited. I'm already limited.
Can I ask?
There's times.
I want to make
there's
sure I
times-
follow you, Mr. Brooks, so I'm sorry for the interruption. If I hear what you're saying correctly, you may have a belief that your access to certain things that would impact your ability to prepare for this case is impacted by the COVID protocols. Is that a fair assessment of what you're trying to convey?
I would say that would be accurate in a sense.
In a sense.
And so if we ask the jail administrator that specifically, is there anything about the COVID protocol that would interfere with your ability to have access to materials or a room? Is that a question you would want answered?
That would be fair, John.
It's gonna keep him
understand
from
what he's
So
trying to
what
ask.
I'm
walking the
understanding is,
parade route and,
obviously,
you know,
Mr. Brooks is allowed to keep
checking
legal
for
material
blood
in his
spatter.
cell. He
That's
will
pretty
remain in his
much
current
what
housing
he
location.
wants, I'm
Access to
sure.
the conference room, it will not change that, which is outside of his housing unit. And access to the phone could be granted upon request in the day room area.
All right.
So I
Thank
do
you.
not believe the protocol limits his access to legal material.
Thank you. Do you have any other questions?
Yes, I do, as far as she just referenced the telephone. To the best of your knowledge, are you aware that there is a certain times that the phone will be available? You have other inmates that,
Let's
have
not
time
talk about
out
other
there.
inmates, but again, I'm sorry for the interruption, but I want to try to get us through these questions. If you're asking,
Okay, let me ask it another way.
okay, go ahead.
Unless another inmate is assisting in his
Because of this
defense,
COVID protocol, I won't
they're
have my
completely
usual
irrelevant.
time out of my cell that I would have regularly. Would I be able to utilize the phone in the same manner that I would be able to use the phone had I not been placed on this protocol? Or would it be strictly by me having to just ask?
I guess I'm unclear as to the manner you speak of. What
All
are
of
you
this would
referring
be
to?
even more
I think I
irrelevant
was very clear.
if he hadn't asked his lawyers.
Are you trying to
You
ask
are
her?
aware, are you aware, which I know you are, that the protocol that I'm on outside of the COVID protocol prohibits me from being able to utilize the phone at certain times of the day? Would the COVID protocol prohibit that any further?
Mr. Brooks, are you trying
Does
to
does
ask
he
whether
want
the COVID protocol
24/7
impacts your phone
access?
privileges?
That's what I just said. No, not in a sense, because I think it's more accurate with the way that I asked it.
But your question
Meaning that-
assumes facts not in evidence and that are beyond the scope of this proceeding. I'm concerned about what, if any, impact the COVID protocol has on your ability to prepare for this case. So I'm going to limit your questioning in that way.
Well, can we at least?
They've got to get things moving. I'm sure there are much more important things to discuss.
Why we're having this didn't have anything to do with.
He hasn't even discussed
limiting
jurisdiction
my
yet
blood
today.
So
That wasn't the real.
He wouldn't
issue.
shut up about it the last 2 days, though.
I think it's related to
I
the,
just wanted that clear. I just wanted that clear.
I understand.
That's all.
And he
I
wanted a
understand what you're
certified
saying.
copy of
I
her oath of office,
respectfully disagree.
which,
That's why I've allowed
as
some
we
of the
know, isn't a
questioning.
thing.
I believe it's relevant to the motion that's before me, for this court to know how the COVID protocol specifically impacts you and your ability to prepare for this case. I understand you might not be claiming the latter to be an issue, but nonetheless, I think it's appropriate for the court to consider those things.
And apparently,
I heard
the last
the jail
last
administrator
couple days,
indicate that the phone privileges would
the
still be
court
available upon
requested
request, and I guess
the
to the extent that that's
prosecution.
different, if at all, from the standard protocols that you're under, I would accept that as an offer of proof.
Okay,
from
the
you.
Well, I didn't agree to that, but the reason why I brought it up.
Leading questions.
I've been on outside of the COVID protocol. The protocol that I've been on for a very, very long time.
Wouldn't be a
So
problem right
my
now.
home use is
The
limited
jury
to
isn't
7
in
hours
there.
a day, which works
He's
out
All right,
for
Mr.
my
Brooks, we're
family.
getting a little
technically
far afield. I need to make a
cross-examining her,
determination on your request.
which
So I'll
Well,
ask you one last.
leading would
I
be
will, Mr. Brooks, I will
acceptable.
ask you one last time. Do you have any other questions for the jail administrator? Because right now you're talking.
I'm
more
sure
about
there
things
will
you would
be
provide.
plenty of objections
So
in
if you
front
have
of
a
the jury
question
as
that's
he
relevant,
cross-examines
please ask it.
witnesses.
I didn't say anything I would provide. Where did I
But yeah,
say?
the court wants the prosecutors
information
to stay at their
through
table
just
instead of
a
standing at
statement
a
about things,
lectern,
that's not evidence,
both for
right? The witness on the stand
opening
is providing
statements
us
and for
testimony. Testimony
questioning
is evidence.
witnesses,
Not
since
that I wouldn't
the
accept certain
defendant won't
statements
be
from you,
allowed
but also understanding the
up.
state has the ability to challenge those by asking questions of the jail administrator or other individuals so that I
And
can
that
make a
means
determination today on
they'll
your
be
motion.
socially
With
distanced
that,
the whole
Mr. Brooks,
trial.
do you have any other questions for the jail administrator?
Well, everything you just said still speaks to.
Except for the bailiff standing behind him the whole time.
Not understanding that I have, Your Honor.
Mr. Brooks, one last time, do you have any additional questions for the jail administrator?
Your Honor, what you're doing right now is you're not being fair right now.
All right, Mr. Brooks has not answered. Mr. Brooks, I need to make a ruling right now. Please stop. He's not answered my repeated question as to whether he has any additional questions for the jail
He
administrator.
wants to ask all the same
Unless
questions
there's
again.
any further questioning from the state based upon the additional questions that were asked, then I'm going to have her step down.
Which, of course, the
Just
objection
want
to that would
to
be asked
ask
and
of
answered.
the court, if you're intending to take up his inmate communication form that was dated September 28, 2022 as well, while Ms. Wollenhop is on the stand. I just have a few questions related to that, Your Honor.
I object to that, relevancy. What does it have to do with what she's testifying to right now today? They're two separate issues.
I'm sorry, I don't know the document. Oh, I do have the document number.
One
258.
witness can testify to more than one issue.
Objection for relevancy.
Hold on, Mr. Brooks. I need to find the document in my record. 258, you said?
Yes.
I'm just going to print that off for ease of my reference. I am going to allow the jail administrator to be questioned regarding document 258. I don't know if Mr. Brooks has a copy of that in front of him or not, so I will print it off in that courtroom so that he has that.
So that I have this correct on the record, you're making a judicial determination to allow testimony of something that has no relevancy to what's being.
You
raised
say
today.
it's not relevant.
How these are two separate issues.
The court recognizes that they're two separate issues, but I also have the authority when considering judicial administration and economies of scale, shall we say. We have the jail administrator here. It's an important housekeeping issue as we go forward. And so I'm going to address it after I address the motion to adjourn that you filed. But since we have her here, I'm going to have the parties question her on that document as well. It promotes judicial economy, and that's my decision. So go ahead.
Can I put Your Honor on notice that I intend to appeal that decision?
You don't need to put the
your-
judge on notice.
Statements noted of record.
You just have to get your objection on
Go ahead,
record,
Attorney
and then
Otto.
you can appeal.
Ms. Wollenhop, I don't believe you have the document in front of you, but. Thank you, Judge.
The record to reflect, I'm handing her a copy of what is in the record as document 258.
Thank you, Judge. I'm sorry.
That's okay. I'll print off another copy for myself.
Okay.
Can someone
From what
confirm
I've
whether
seen
that
over the
document
last
is
week,
given
I
to Ms.
really
Brooks
like
as
these
well? I did print it to
prosecutors.
the printer over there. I have that ability.
Just like the judge.
It was.
They're
All right,
dotting
thank you.
their
The record
I's
to
and
reflect,
crossing
he
their
has also been
T's.
provided with a copy of docket number 258.
I'm not acknowledging that document, Your Honor. I'm not acknowledging that. I don't consent to.
All right, I'm going to mute him because he's interrupting. Mr. Brooks, it's a document you filed. So,
It's his
it's a
document, and
document
he's
that was filed
objecting.
through the inmate communication form process. It was scanned in on October 3rd, but it's dated 9/29 And it's directed to either clerk of court / Judge Darrell. So go ahead.
Thank you. Ms. Wollenhop, you've seen a copy of this document previous to today, correct?
Yes, ma'am.
And you're aware that it's dated September 28, 2022, correct?
Correct.
And purports to have been written by Mr. Brooks himself, correct?
Correct.
And in this communication to the court, Mr. Brooks indicates that he is on a quote, keep separate, end quote, in the jail, correct?
Correct.
And at the conclusion of the form, near the bottom, the last two sentences, he indicates that he has no
I
access
like
to the
to think I
materials
could
he needs to
be
prepare for
patient
trial
enough,
because of the keep separate order, correct?
but I don't think
Correct.
I
That's what he states.
Okay. Is
would
that
be as
a
patient as
truthful
Judge
statement?
Middleton,
Well,
It
let
is.
me ask him different.
or
That's
as
okay.
patient as the lovely
just read
Judge
that.
Doro before us.
Did Mr. Brooks have
She
access
really has
to
been
his
excellent.
legal materials during the time that he was under a keep separate order?
Yes, ma'am.
Again, that would be the banker boxes of written discovery in his own jail cell.
Correct. Anything that was in his jail cell, he would have access to. and
Okay.
He would also have access to the conference room and a tablet
And the
in his
tablet.
cell.
Okay. And that's the legal materials that are provided to him are on that tablet and on the computer in the conference room.
Correct.
And nothing about that keep separate order affected his ability to access those things, correct?
Correct.
Thank you. I don't have any other questions on this topic, Your Honor.
All right, Mr. Brooks, I will unmute you. Do you have any questions on this topic for the jail administrator?
Yes, I do.
Emphasis,
Just
this
stated
topic.
on record that I had access to all materials for trial prep during the time of this keep separate, correct?
It doesn't specifically say what you don't have access to. So yes,
No, I
what was
said,
in your
did
cell.
you just say in open court on the record that I in fact had access at the time of this keep separate?
2 items in your cell, and you could have access to the conference room to view electronic legal materials.
So am I correct in saying that
Since firing his attorney,
you
he has
brought over
asked for access to the law library or to the computer,
that I was in fact
but then
in one
didn't
of those
follow
conference
through and then
rooms,
complained that they
and
didn't give
I
him
talked to you
access.
face to face, is that correct?
You were in a conference room and we spoke.
And I informed you then that I was on the keep separate, correct?
I do not recall that.
I specifically told you that I was on a keep separate with the guy that was in the cell next to me that had placed that on me, correct?
I do not recall that.
So you don't recall, you can recall that we spoke, but you can't recall what we spoke about.
I informed you at that time I was delivering the banker's boxes.
And I took the liberty to explain to you that I was on the keep separate and that was gonna hinder me being able to prepare. Is that correct?
I do not recall that.
You don't recall that, or you don't remember me bringing it up?
I do not recall us having a conversation regarding the keep separates. We had a conversation regarding me delivering your legal material.
So is there a way to verify when the keep separate went into effect?
Objection relevance. Well, hold on. Mr. Brooks, as I read this inmate communication form, and perhaps it's just a simple question, when you wrote it, did you have access to the banker's box of materials yet?
No, I did not.
It's almost like it takes time to get things from your attorney when you fire them.
That
Jail has to make
she
sure there's no
brought
contraband.
discovery materials over on Thursday, the 29th. She did say that in open court on
I
the
agree.
record.
Yeah,
This-
she said that
this-
previously.
This inmate request was written on September the 28th. At that time, I was already on the keep separate protocol, which does not allow me to come out of my cell.
But is the issue the keep separate protocol, or that you didn't have access to the materials that we've now established through testimony you had access to once they were delivered to you?
The keep separate protocol in itself, Your Honor, restricts the two people that have the keep separate from being able to come out of their cell until one of them is moved. Whether that be to another unit in the pod or a different pod, that part I can't speak to, but neither of the parties are able to come out of their cell until someone is moved. And the reason why I wrote initially why I wrote it was because that stops me from being able to shower in the unit, because officers would have to then take me to another part of the jail, sometimes in the pod, in a secure shower.
Once
as they
again,
call it, which is
how does his
Sir, I'm just gonna
ability
stop
to
you because
shower
honestly,
impact his
whether
ability
you have
to
a
prepare
shower
for
or not
trial?
is not relevant to the issue of whether you had
And the
access
judge
to the
agrees.
materials you need to prepare for your case. So I read this inmate communication form, especially that very last sentence. I am respectfully asking and requesting that my trial be slightly delayed as I have no access to the materials needed to prepare for trial. Thank you. So my question to you is, and I think you've already answered it, but I want to make sure, at the time you wrote this inmate communication form,
It's almost like he shouldn't have fired his attorneys
had
the
not
week
yet
before
been
trial.
delivered to you. Is that your testimony?
He should have kept them or fired them months ago
been delivered
and prepared himself.
Maybe 10%.
It's all just a delay
Of the
tactic.
discovery materials that was provided to me by my former attorneys on this matter.
Right.
That
So you,
that in itself was very, very voluminous in itself.
Sir, we had a prior hearing related to the access provided to you and when the materials were provided. You may recall that Attorney Perry even testified over Zoom audio about that. The jail administrator testified as well. To me, that record is very clear that the materials that were provided by your defense attorneys following their discharge on your case were received by you
It's
on
possible.
September 29th of 2022. That has been established. No one is
Except
disputing that.
he's complained
So
through the whole thing.
that's the record that I have before me. I understand what you're saying about the keep separate, but also at that hearing, it was
I
made
think you're
very
onto
clear
something.
to everyone
He ran
that
through that
the
crowd
jail administrator gave some
because
specific directives as it
BO.
relates to you and access to certain things.
That's the only explanation.
I do recall that, Your Honor. And one of the questions, if you recall, one of the questions I had about what you just said was, did all the officers know about that specific order? I'm guessing it would be called. I don't know what it was exactly, but the information that was to be passed down from Ms. Wallahouse to the officers.
Right. And I'm not going to revisit that because you were given ample opportunity when we first addressed that to ask questions and to provide other information, meaning statements from yourself. And the clear
You wouldn't
record
be
from
pro
that
se
is
though
that
if you
the
didn't go
information
over the
was
same
put into
thing
the jail management
again and
system.
again
It was
and again.
documented, and that the jail administrator had no information to suggest her employees did not have that information and honor that information. There was no testimony from anyone else to suggest that that wasn't followed. So
I would like to say something for the record, Your Honor, on that.
go ahead.
I've had that exact
Speak to
problem,
what you
just
said on that.
trying to get away from it.
It's possible that all officers were not aware of that. I even talked about this with an officer who worked just last
In
night
fact,
that wasn't even aware.
Leonard Skinner wrote the song That Smell about this exact problem.
That issue came up because I specifically asked
In
to
addition to
utilize the
classic
tax.
cars, I like classic rock.
So in my mind, that would say to me that I'm not trying to argue if the order went out to the officers. That's not what I'm disputing. I'm just disputing the fact that every officer that works in my pod is aware of that.
All right, thank you. Any questions at this point for the jail administrator? Again, not related to the shower, but related to access to materials.
Does a keep separate protocol, Ms. Wildhawk, does a keep separate protocol restrict inmate movement in any way?
Objection relevance.
Sustained.
Did you
Overly
make it
broad.
to the Roger Waters concert
Next question.
earlier?
Or rephrase.
I guess it's last month now, almost a month ago.
Does being on a keep
I
separate
was
protocol,
way up in the nosebleeds, but
or rather,
my God, it
I'll
was
refer to
amazing.
myself. If I am on a keep separate protocol, with that.
And I put
intent,
Zeppelin ever so slightly ahead of Floyd, but they're
to
1A,
only
1B.
being in my cell and being able to only utilize what I would essentially have in my cell.
That's a compound question, so you have to break it down one at a time. So rephrase.
Would a keep separate protocol restrict me to cell confinement until arrangements can be made for me to be able to resume my normal activities?
Judge, I would prefer not to answer that. It's due to jail operations. We would look at each individual in each situation. I think it's overly broad.
Mr. Brooks, I'm going to honor the request of the jail administrator to not answer that because it would require her to provide information regarding jail operations. It's overly
It was a
broad.
long
We need to
delayed
limit the
concert.
question, to how this protocol limits you
He
specifically as it relates
played
to
at the
access to
Delta
materials
Center.
needed to prepare for trial.
I think September 8th.
Generally, whether you're on any kind of restriction,
I had
whether,
tickets for it for
but how,
over 2
the
years,
focus
but it
is
was delayed
how this
twice.
impacts your ability, if at all, to access materials needed to prepare for trial. Other than we've established that you didn't have the materials from your attorneys that were provided after they were discharged by the court until September 29th. I mean, we've established there was a gap, right? I granted the motion and allowed you to represent yourself on the 28th. That was a Wednesday.
It was
And then the
amazing.
materials,
It
even
was
though
worth
they
the wait.
were turned over to the jail it sounded like in the evening on the 28th, there was protocols in place to go through that. And then those were provided to you on the 29th.
Obviously,
That
I
is
wish
well established on the
Gilmore and
record.
Mason had been involved, but
So I
he
understand
had
that.
phenomenal musicians.
We've addressed that in part previously.
It was just an
So,
amazing concert.
I know the state wants me to address this, and I think I know the reason why. But if there's any question you want to ask the jail administrator about what was going on the 28th or 29th, or even going forward, that would impact your ability to have access to these materials, that's the type of questions you need to ask, okay?
Well, I asked the question and I was told that it wouldn't be answered. I asked at the time that she brought over the discovery materials, was she aware that I was on a keep separate protocol at that time?
That's the answer.
Sustained.
It's only relevant if the keep separate order keeps him from the materials. How is
The answer
this
is already
relevant?
provided. She doesn't need to answer it again. Next question.
What was the answer to that?
The record speaks for itself, sir. Next
I
question,
don't
please.
recall her.
Almost
I don't
like he
recall
should
her
have paid
answering that
attention.
specific question.
Next question, please.
Can you provide for me when she answered that specific question?
Mr. Brooks, do you have another question for the jail administrator?
Is it gonna be answered? Is it
I
gonna be
consider
The record speaks for
metal
itself, sir.
through to the wall
Well,
as
the record
the
speaks for itself.
definitive Pink Floyd era.
Then that question should be able to be answered.
And that's
Were
most
you
of what
aware
Roger played.
that at that time, I was on a keep separate protocol, that it was already.
And I've been
in
meaning to see Ozzy Floyd and
that I
Brit
was on that
Floyd,
protocol.
but haven't managed to yet. But it's on my list of things to do.
What date are you referring to, sir?
The date that you brought over the discovery materials, were you aware at that time, on that date, that I was under a keep separate protocol?
You previously asked me if I recall the discussion you were informing me.
But that's not the question now, though.
I was aware.
The question is the day that you brought over the discovery material. Were you aware at that time that I was on a keep separate protocol?
I can't state for certain at that moment in time. I was aware you were on a keep separate. I can't state what date that I was made aware of that. I think it was due to a complaint that you sent forward to the jail.
I sent no such complaint. The complaint was by the other party. Were you aware of that?
Judge, I prefer not to answer this. I don't understand how it impacts what he
Yes,
has
Mr.
had
Brooks, we're
access to.
far afield from the issue at hand. So I'm going to ask you one last time. Do you have any additional questions for the jail administrator?
What are you allowed and not allowed to do on a keep separate protocol?
Objection, relevance.
Sustained.
And it's jail operations.
All right, then I gave him the opportunity to ask questions. That was his last one.
I wasn't done.
Mr. Brooks, I'll give you one more opportunity then. They need to be relevant. They need to be within the bounds that I've already discussed.
And they need to not be redundant.
No,
I just asked this.
The issue is limited to the impact of the keep separate on your ability to have access to materials needed to prepare for trial.
But Your Honor, with all respect, every question that I asked that had relevancy to that was either overruled or
It's
directed
almost
not to
like
answer
you
that.
weren't asking
Mr.
relevant
Brooks?
questions.
Mr. Brooks, you indicated you had other questions. I will give you this opportunity if you can ask a question that falls within the scope that I've previously identified. Do you have another question?
But it's more important to argue and obstruct.
On a keep separate protocol.
It's vague, Your Honor. The question is, was he allowed out of his cell to access his legal materials?
That's not what I asked.
Right, the
That's
question
not
you
what I
asked, the objection is sustained. If you'd like to ask the question suggested by Attorney Opera, that would be permissible by the court.
No, I would want to ask my own question. Thank you. Was I able to come out of my cell on the keep separate protocol?
Judge, I would prefer not to answer that.
It's beyond the scope of the inquiry right now. The jail administrator need not answer that question.
Can you give me the basis why, Your Honor?
It's beyond the scope.
It's almost like she had just given the
I
basis.
understand.
Mr. Brooks, do you have any other questions?
I do not understand what beyond the scope means. That was a direct.
One last time,
You don't
sir.
understand
Do you have any other
anything.
questions?
That was a direct question.
All right, I'm going to mute him because he's now not being responsive to the question that I asked, and that is, does he have any questions to ask the jail administrator?
Here comes the sign. Here comes the
within
sign.
scope that I've previously outlined. Any follow-up from the state?
No.
All right, thank you. You may step down.
And I have to wonder, is the next issue going to be relevant? Because I'm sure there are other motions in front of the
All right,
court.
does the state have any other witness or evidence you want me to consider related to either of these issues, the motion to adjourn or the inmate communication form dated September 28 of 2022?
Nothing else from the state, Your Honor.
Mr. Brooks, do you have anything else related to the inmate communication form dated September 28 of 2022? Since I obviously included that after we took up the other issue.
Yeah, I'm still, I don't understand how, any questions that I was asking, are not allowed to be answered.
Mr. Brooks, I'm asking you very clearly, do you have any other information?
She told you last week.
Testimony.
You're
or
held to the
evidence you wanna
standard of a
present
lawyer.
As it relates to the inmate communication.
Your
form dated
understanding
September 28
is down to you.
Yeah, I would like to, is there a way that we can verify the standards of the keep separate protocol?
Mr. Brooks?
To be able to show. the
Mr.
court.
Brooks, please listen very carefully. There's a question I'm asking you is, do you have any other evidence?
Intend to being asked a question
document? All right,
when
then
you
I'll,
can't even answer the
all right,
question
I'm going
without
to mute
asking
him
me.
once again. He is not answering very clear questions. I asked him if he had any information, evidence, testimony,
Hidden
documents he
behind the
wanted to
mask.
present.
But his
Instead,
gums
he
are
asked
still
me if I could
flapping,
verify
even though he's
that,
muted.
is not within my role. This is an adversarial system of justice here in the United States and in Wisconsin. I preside over that, but it's up to the parties to present information,
Exactly.
evidence, testimony to
It's
the court
almost
so
like
that
it's a
the
game
court
to
can,
him.
address the requests and make decisions. I would refer Mr. Brooks back to the waiver of attorney form that was discussed
Oh,
last
the
week.
sign's out. It's because he's the only one playing the game. And the game has no bearing on the outcome. Once Ferretta was done,
It is document
his understanding was
number
completely irrelevant.
244, scanned on the 28th day of September 2022, wherein Mr. Brooks was advised that the judge cannot be his attorney, cannot give him any legal advice. The district attorney cannot be his attorney, cannot
Wait,
give
she
legal
can't
advice.
practice law
The
from the
judge,
bench?
district attorney, and court personnel are not required to explain court
I'm
procedures
shocked.
or the law, among other things, and that he is required to follow all legal rules and procedures that an attorney would have to follow in court.
We all lose.
He was also advised, and this is just one
Him
part
more
of
than
that
others,
form, that it
though.
may be difficult for him to present evidence. It may be difficult for him to do a good job as his own attorney. We discussed
Hey,
at
I've
length
lost
the
at
advantages
solitaire
to having an
before,
attorney,
so.
the disadvantages to representing one.
But I realized it was a game.
And what he is asking this court to do is to explain the law, and could also be described as a request for legal advice. All right, with that then, I'll certainly take up any arguments from the parties as it relates to both of these issues. I'll start first, though, with the motion to adjourn. Mr.
No
Brooks is holding
comment.
up the objection. That we're not taking testimony at this time, so the court does not feel compelled to acknowledge that any further.
And I know I said
other
it
than to
earlier.
say
I
the fact
really
that he's
like this
objecting is
judge.
noted for the record. Mr. Brooks, I'm going to unmute you because it is your motion to adjourn these proceedings. And as such, I will give you the first opportunity to
With a case like this,
talk about.
I don't know how
the
they
evidence that I've heard here
assign
today by way of
judges in this
testimony,
district in
and
Wisconsin.
to make your specific request known to the court.
Usually,
And then we'll give the
there's
state
some
an
sort of
opportunity, and then I'll decide.
randomized system to assign
All right,
judges.
Mr. Brooks, what is your argument as it relates to the motion?
With
to
a case
adjourn?
like this, though, I could totally see them saying, you're the best judge to handle this.
Pretty clear why.
And if they did that,
I don't think I need to.
I wouldn't be
argue
surprised.
anything. I don't think
Because she really
I
has
need
been
to
excellent.
provide anything more. it's clear to me that the wrong person was testifying. She said that she was not present for the said COVID test. So there's, to her knowledge, no way to
This is still irrelevant.
say for sure why I wasn't provided with the test that I should have been provided with if that becomes an issue. Honestly, Your Honor, I'm powering my way through this hearing. I feel like total crap, to be honest with you.
Well,
don't
go
feel good
ahead
at
and
all.
take the
Uh,
instant test.
My reasoning for raising this issue, like I said, was
Is for
strictly
delay.
a health and safety thing. It didn't have anything to do with trial prep. It didn't have anything to do with access to anything.
It's for.
It was strictly because, like I stated before on record.
Then why
I've
did
never
they
had
spend the
this
last
issue
hour
come up.
discussing access?
Like I stated before on the record, I've had people that I know, loved ones, close people, pass away from this COVID disease. Frankly, I'm terrified because I have yet to even get the results back.
It'll save you from 40
to
years
say
in
whether
prison.
I'm positive or negative. I am fully vaccinated. I've never
Fully
tested
vaccinated, 40
positive
years
for
old.
COVID. And frankly, to even be told that it's a possibility that I could have COVID, it makes me very afraid. Which is one of the reasons why I was so concerned about the actual protocol, because once they informed me that I would have to be essentially quarantined and isolated, the first thing I was thinking about was how would I be able to use the phone and be able to tell my family what's going on? How would I be able to reach out to my kids and things like that to let them know, hey, I got a health issue going on here that I'm worried about? That was my concern. And my intention was
I mean, if that's your
to at
concern,
least be able
you
to
can have
get
the jail reach out to
the
them.
results back so that I know, okay, I'm good to go. Let's keep the ball rolling. That was my intention. Like I said, I just came to the knowledge this morning when they called me over to do the test. I had no idea that was what they were going to do. Like I said, I didn't understand the protocol until it was explained to me. So I'm just coming into this knowledge as well. I'm still trying to wrap my head around it.
If he keeps this hearing going till
With that, Your Honor,
midnight,
that's
they'll
pretty
have
much
no
all I have
choice
to
but
say
to,
is the
push
intent
this
of it was strictly
trial
that,
start till noon tomorrow.
you know, not one to, if I am positive.
Oh, thanks
not
for
going
hanging
to
out, man.
infect
It's
anyone else
like
or
I said,
put anyone else
it's
in jeopardy.
definitely helpful
And
having
also
someone
doing the things that I may
to
need to
talk
do
to
if I'm
instead of
found to
just
be
talking into
positive,
the
doing the
ether.
things that I need to do.
And
That was
hopefully
my
I'll see you
concern, and
tomorrow
that's why I raised the issue, Your Honor.
or whenever the trial does start.
Thank you, Mr. Brooks. I'm going to turn to the state then next. As a reminder, don't interrupt them. Thank you.
Well, Judge, I'm glad to hear Mr. Brooks say this is not a trial prep issue and merely his concern for the health and safety of others. The court has already made the record that we can safely accommodate Mr. Brooks in this courtroom without risking
I'm glad you called it
the health and
insight.
safety of other individuals, even if
Some people
he
would
should
just
have
call it shit talking.
positive results on his COVID test. We feel comfortable with that as well. The jail can still move him properly. The bailiffs in the courtroom can still respond to his needs properly. So if it's merely a health and safety issue, I believe we've easily overcome that, Your Honor. I don't put much credibility in the
Of course, if he
excuse
does
me,
test
comments of Mr.
positive,
Brooks here,
it could
as
be
Detective Regland just advised me, he
prejudicial
made
to force him
17 attempts for phone
to
calls
defend
just
himself
this morning alone. So
while
his statement
sick.
to the court that he was worried about being able to call his family, I think, really is questionable. I also would like the court
Objection.
just to acknowledge that document 258, and perhaps that's a moot issue at this point, but I still think a record should be made that no matter what circumstances have arisen with Mr. Brooks specifically in the confines of the Waukesha County Jail, he has always had access to his legal materials, the discovery in his cell, and the necessary tablet and computer so that he can prepare for his case. So I would ask you to deny the motion to adjourn
Told you.
because of the COVID protocol, and to the extent that there was a prior motion to adjourn because of a keep separate order, that also is inappropriate at this time. Thank you.
Thank you.
I said I don't know how they selected the judge.
I'm just pulling up a
I-
couple of documents.
I
so
can
review them
guarantee
electronically as I make a
The
decision
district
here
attorney
today.
chose their best prosecutor, and she's it.
Your Honor, may I state something for the record?
You may briefly respond. Go ahead.
Um,
And the other two with her
all
are
I
also
will
excellent.
recall, one of the detectives that is sitting right behind the prosecutor's desk right now, Detective Casey, just went through something similar with COVID and was not present.
That's
for a couple of
irrelevant.
hearings. I don't know how long his protocol was. I can't speak to that situation. It's not my business, frankly. But
It's not the court's business either.
he wasn't present in the courtroom, and I think that has relevancy due to probably him feeling the same way, not wanting to infect anyone else or put anyone else at risk.
I realize this is nitpicking,
I don't see where there's.
but he's said it so
any
many
difference
times.
in
It's
my
relevance,
situation.
not
Also, very
relevancy.
briefly, for the record, I was able to make a phone call. Phone call attempts, because they were attempts, this morning after I came from getting the test, because I raised the issue. I said, since I know that I'm going on this protocol and I'm already out of my cell, can I take this opportunity?
Why is
to
it
try to
still an issue
notify
then?
my family of what's going on? That's why there were so many attempts, because I wasn't able to reach
Your
my
family not answering
who
is irrelevant.
who pretty much has access to my kids. If I need to get some information to my children, she's the one that
I feel bad for
is in
those
charge of all
kids.
that.
Imagine having
I just wanted to
this
state
as
that
a
for the
father.
record.
Thank you, Mr. Brooks. Well, the court has heard from
And I
Mr.
say
Brooks. The court
father
has heard from the jail
very-
administrator. The DA has provided some
very
additional information as officer
loosely.
of the court. Let me address Mr. Brooks' motion to adjourn. He filed an inmate communication form earlier today, raising this issue. He is on a protocol. He is not tested positive. He provided information today that he is fully vaccinated, that he'd been telling officers for days that he had not been feeling well. We do not have the test results today. He was offered a rapid test and refused. He reports symptoms of fatigue and that he can't taste.
Almost like the
indicated,
lack of a test result is on him.
It was a few days ago over the weekend that he started experiencing these symptoms. Now, during his
Wasn't
time
a problem
here
for
today,
jury selection, though.
Mr. Brooks, despite the disruptions, has been very clear, coherent. He has asked questions. He's made objections. I know he might not like the word argument, but that's a word that we use in the adversarial system when the court asks the parties for their positions on certain issues. We call it legal arguments.
And
or
he's
arguments
been
for short.
combative
Doesn't mean
in his
have any
arguments.
connotation that it's unruly or disruptive or a disagreement. It's just the word that we use in the legal system. He was able to
Same as
articulate his
understand.
positions to the court. He at times appeared animated. He appeared
That doesn't
again,
mean
to understand
cartoonish.
what the court's either questions that the court was posing to him or information.
Because I'm
the
sure
court was
Mr. Brooks
providing
will
to
watch
him.
this at
He
some
clearly
point.
was
you
able
know.
to
Just want to clarify for him.
Mr. Brooks, please don't interrupt me or I will mute you. He was able to follow the questioning and answering process with the one witness who is here today. I appreciate that he clarified that he was not making this request due to trial prep or access to material issues, but it was really related to his health and safety concerns. At this point, there's insufficient information on the record to find that his concerns are anything more than speculative. And given my observations here in court today,
Courts love
he is
speculation.
very ably or very able to assist in his own defense. He's able to present arguments, etc. I've already noted. We are able to accommodate the health and safety concerns in this courtroom. We confirmed that where he sits at the table, if he's in this courtroom,
Which he won't be
there
for
is
very
no
long.
one around him who would be within 6 feet. That is an important consideration that has been one
might
of
have to
the
At the start of every day of trial,
topics of guidance from the
ask
CDC.
for
Certainly,
guesses on how
one of
long
the
before
or
he's
part of
kicked
the
out the
guidance we
first
have
time.
received from the county. The most recent county protocol talks about isolation for 5 days. Clearly, if he had the onset of symptoms over the weekend, which is what he reported, and he has not had any escalation in those symptoms, as has been demonstrated by his ability to participate in this hearing. The court will find that there are no present health and safety concerns other than what I've noted with the 6 feet and social distancing. I'm not
Once
going
again,
to
no
adjourn
attorneys.
this trial.
So he's got 6
Um,
feet.
I'd also put on the record that he has not been denied access to materials. He has full access, even with this protocol. He has had access even to the phone. There's been what's been referenced by both the state and Mr. Brooks about attempted phone calls. I'm not so concerned about whether phone calls go through. It's the fact that he's been given access. Whether he connects with someone is not the issue.
As I said earlier.
I'm also concerned about the
See, I
fact
would
that
make a good
he
judge.
would not answer the court's question directly about whether he would take a rapid test. To me, his credibility is at issue with that. If he were truly concerned about his own health and safety, he would want to know immediately.
At issue is putting it
and
mildly.
he repeatedly would not answer that question and
He has
instead
no
wanted to debate
credibility.
about what test was provided to him and why
He does
perhaps
have an
it was not.
objection sign, though.
All right, you're interrupting me. I'm going to mute you. So that is my record here. Today, I agree with the state's assessment. This is nothing more than a delay tactic, given the information that this court, and once again, on the record before me, there is nothing to suggest that he is actively being impacted by COVID-19, and that any health and safety concerns he has for his own safety can again be met. The jail is able to get him here. The jail, of course, is responsible for his medical care. We can keep him 6 feet
if
away
he
from any other person. Obviously, if he's
does
moved
have
to the other
it,
courtroom, that provides a greater
the
buffer
stress of
as well.
trial
Um,
could
and
exacerbate it.
for all of those reasons, I'll deny
I
the
say,
request to
you know,
adjourn.
not being a
As
medical
to
professional.
the issue that was raised in the inmate communication, obviously this was a form that was sent by Mr. Brooks on Wednesday September 28th of 2022. That was the day on which this court granted his request to represent himself. We know from the record, not only from today, but previously, that on September 28th of 2022, what he would have had in his cell would have been materials previously provided to him by his attorneys. His attorneys, through Attorney Perry, dropped off 3 bankers' boxes worth of materials and a flash drive to the jail.
I
later
understand
that
his
date.
fired attorneys were present
And the jail
for
followed
jury selection.
whatever
I don't know if
protocols
they're there
they have with
today.
regard to those materials and reviewing them, and that those
But
materials were provided to Mr. Brooks on
I
September
think they are
29
well
of
positioned to step
2022.
in if the court
He's
deems
confirmed
it
through the
necessary.
most recent request to adjourn that he
And
wasn't
now would
even
be the
making
best
that
time to do
request
it. He's
based on
already
any type of
shown he's going
access
to be
limitation
disruptive.
to materials or things of that nature. Although not a specific statement by him, this court would take that to mean he has been able to continue with his preparations. I'd also put on the record that there's no doubt that being in trial can be exhausting. We, of course, had 2 afternoons of hearings last week. Of course, he was provided with a lot of material. From my perspective, he clearly understood the perils of self-representation and
She
the
made sure he
volumes
did.
of material that he would need to review perhaps a second time because he had some of them, or for the first time. Those were things that were clearly, he was clearly advised of before I granted that request. And then, of course, we had 2 very, very long days of jury selection yesterday and the day before. Given the way this jury selection progressed, we did not start with court until today at 1:30. Frankly, part of that was done not just to provide access to the media pool and the cameras and other things that needed to be installed, but honestly, to provide a little bit of a break for myself, and I would hope for the other parties as well. Of course, everyone continued on with their preparation, but I actually understood this request. I may not have referenced it previously, but that really factored into my decision to start later today as well, and to not bring the jurors in until tomorrow.
Plus, Court TV
So
needed
I
to
am
set up their cameras.
satisfied that Mr. Brooks has access to his materials that he needs to prepare for trial. As I indicated earlier, I have also provided to him the Wisconsin Criminal Code and selected traffic statutes, including the Wisconsin Rules of Evidence. It's from 2018. While there might be some slight modifications to some of the substantive statutes, this would give Mr. Brooks a very good reading as it relates to the rules of evidence and the statutes that relate to the charges he is facing. I'll provide a copy of that, a photocopy of the cover, so that it's docketed in the case as well. While this court is under no obligation to do that, since I was able to locate that.
No obligation,
Putting that
but she
on
doesn't
alone
want
to
it
Mr. Brooks.
overturned.
He also needs to understand, though, that at this point it is for use in the courtroom. I would entertain a request that I go back with him to his room on a couple of conditions. One, it would be that he agrees to bring it to court each day.
She really has
2,
been
that
an
it be
excellent
maintained in its
judge.
current condition. And then 3, that it's returned at the conclusion of the trial. So that will be for him to decide how he wants to do that. He has been raising the sign objection at all times during my oral decision. I would note the use of an objection is when the trial is in an evidentiary phase or a motion where we're talking and addressing the receipt of testimony and evidence. It's a mechanism under the law by which a party objects. They usually state either a 1 or 2 word basis. Sometimes it might be
I
a
like
short
how
sentence
she's
or 2.
explaining what an
Sometimes
objection
the other party's
is
given an
for the
opportunity to
record.
respond if it's self-evident
On
to
the
the
record,
court as
for
to
the
either
record,
what
let
the
the record
objection is or
show.
the basis for a granting or denial. But the court rules on it, and then the parties move on.
That was for our sovereign
Those are the
citizens out there.
not only expected procedures for this case, it also comports with just the basic tenets of civility and respect, that you don't interrupt. Again, an objection is a legal basis to interrupt, but it's done in a way that's respectful. Simply holding up a sign that says objection is not does not comport with those expectations or procedures. All right, so I've addressed those two issues. I have a list. I'll tell the parties what's on my list, and then you can add to that as well. I do know the state filed a motion for reconsideration, so that's on my list as
They're not going to
well.
have dinner tonight.
I wanted to touch base on the request for an interpreter. Again, the motion for reconsideration. I've already addressed the subpoenas. Madam Clerk, can you just confirm for me that they were signed by the clerk's office and then the 10 copies?
I
were
assume
provided to
they'll
Mr.
have
Brooks?
non-English speaking
While he was seated in the courtroom.
witnesses. I assume that's why they
At
requested
11:18
an
this morning, he was
interpreter.
also provided with copies of subpoenas. Do you know how many copies were provided? 21 this morning, an additional 10, I believe, this afternoon. So he has those available for his use. I've already addressed the statute book, so I can cross that off my list. And then, of course, preliminary jury instructions. Now, I know Mr. Brooks, I think, did not bring his with. I wanted to make a change to those before I printed off a
It's going to be
copy
fun
for
going
him.
over jury instructions.
It's
Oh
not
boy.
a huge change. It's really just an addition. And it has to do with some of the language that I have been stating to the jurors if there have been disruptions. Not every time, but I do feel it's important to put some language in after jury instruction 70. But I'll get to that. We'll probably do those last. Attorney Opper, anything you would add to the list that I have?
Yes, Sharon, I just wanted to understand some of the logistics as far as objections and cross-examination and exhibits.
This wouldn't be
and
an
I
issue if
also
you had
have
attorneys.
The state's witness list prepared and filed. I filed it at the start of this hearing. I'm sorry, did I say witness list? Exhibit list. 8 pages right now with 140 items. I was going to
Would be way late for a
make
witness
that available.
list,
So I guess I have
especially
a
since
question
they
about
needed
that,
it
and I
for
don't know if
jury
we take that up right
selection
now or
the
not.
last 2 days.
I have one other, give me your whole list though too, and then
Okay.
I have one other thing I need to add as well.
And then criminal records for state's
mad.
witnesses. That was it for my list. Then the rest overlap with your list, Your Honor.
I know Mr. Brooks appears to be talking to someone and hand gesturing. Unless he writes a note that he has a topic he wants to address for me at this moment, I'm going to assume he's just directing his commentary to the bailiff that's in there. I will unmute him
poor bailiff.
momentarily to ask him a question, and that question is whether there are any housekeeping issues on his list. All right, Mr. Brooks, are there any additional issues?
For
that
housekeeping,
you
he'd like
believe
the
need to be
maid
addressed?
turn down service.
Mr. Brooks, can you hear me? Mr. Brooks? Do you have any additional issues to what I've already set forth and the state's added to the list of what I will call generally housekeeping issues, other than perhaps the motion for reconsideration? That's not housekeeping, but
I was having a side conversation with the bailiff about something, so I didn't hear the last part of what you said.
Almost like you
it's
should
my
pay
understanding
attention.
that the bailiffs would not be having a conversation back with you or at you during court proceedings. So I'll have to confirm or deny that with them. Becky, if you could talk to the bailiff, please.
Uh-oh. I hope he didn't get the bailiff in trouble. That poor bailiff. Of course, being yelled at by Brooks should be punishment enough.
All right, so it's my understanding you were asking the deputy how to pronounce a word. Did he provide a response back to you, Mr. Brooks?
A kind of a response.
What do you mean by that?
It was kind of a response.
Even when he
You
can
provide
get the
a response
deputy in
verbally?
trouble, he's non-responsive.
I'd rather not say, Your Honor.
I'll have to get clarification from the bailiff later on. He's coming in here. Okay, thank you.
That poor guy.
Did you provide a response to Mr. Brooks?
I just told him I didn't understand the word he was asking me. He asked me to pronounce what the pronunciation of a word was, and he spelled it to me. I said, I don't know what that is.
Okay, thank you. Mr. Brooks, I'll ask you one last time. Do you have any topics that you believe should be on the list of housekeeping items to address today, other than the ones I've provided to you?
I did not hear.
He'd like a mint on his pillow.
All right, listen to me now because I'm going to go through the list.
That's housekeeping, isn't it?
Some of them we've already discussed, so I'm going to give you my whole list and I'll say whether we need to address them or not. We have to address preliminary jury instructions, the state's request for an interpreter, the state's motion for reconsideration.
I'd like to know what they want reconsidered.
I'll get to that momentarily. I've already addressed the subpoena request from you.
Because I wouldn't think
I made a record of that.
Brooks would have
I already
won
addressed
any
the
motion so
fact
far.
that I provided you with
This must be from
selected
his attorneys
statutes.
prior to last week.
If you didn't hear, I'll state this part again. The book that I provided to you that was on your table when you got into court today, and that I believe is on the table, or at least was taken over when you were removed to that courtroom, is the Wisconsin Criminal Code and Selected Traffic Statutes, including the Rules of Evidence 2018. It's
That
a
all
State
could have been
Bar
on his
Wisconsin
tablet.
Pinnacle publication. It's probably about 2 inches thick or so. It has a reddish or maroon in color cover and binding.
It's 2 inches
That's been
thick, but
provided
he
as a
probably only
courtesy to
needs
you.
about
It's been
3
provided
pages
to
of the
you
statute,
to use
plus
in the
the rules of
courtroom.
evidence, which
I
are
would
about
entertain a
1/8 of
request
an
from
inch of
you
the
if you
book.
want to take it back to
I'm
your
guessing.
cell as you prepare on the following conditions. 1, you agree to bring it to court each day. 2, you maintain it in its condition presently. And 3, you return it at the conclusion of trial. I'm not asking you to
It'll take
make
him a
a
long
request
time
at
to
this
replace
time.
it at
will
11
stay in the
cents an hour
courtroom
prison
unless
wages.
you at some point make a request. The other issues,
If he
hold on,
damages
sir,
it or
let me get
loses
through my
it.
list. The other issues are logistics regarding objections and cross-examination, the state's exhibit list, which was filed earlier, criminal records for state's witnesses, and then I have an added topic related to
That's some good
Court
impeachment
TV,
material for him.
exhibits and FCC rules, and just some things that may be impacted during the broadcasting of the proceedings because of the FCC rules, which I will claim I'm not an expert on, but I felt compelled to at least tell the parties. I'll start with that so I don't forget.
FCC
And that
rules.
is,
There's gonna be
I have been
explicit
advised that there are
content.
FCC rules that may require graphic images or videos to not be broadcast. And I know the state at
Doesn't
one
matter
point
for
had
the
made a
internet
request,
stream.
and we had talked a little bit about individuals who might who are victims appearing in a remote location and watching the live stream and seeing those exhibits. And originally I had planned to utilize
There's
Zoom,
not
and
enough
there's a
room
share
for all
screen
the
option.
victims in the courtroom.
I'm not going to be utilizing the Zoom because of now the new mechanics for the live stream and the pool feed that Court TV has taken over and is providing to all of the other media that wants access to it. So I just wanted to make you aware of that.
I need to bring more water in with me
I believe there was a
tomorrow.
workaround that was accomplished with the cooperation of Court TV and the county IT, so that the victims will be able to view whatever is being shown in the courtroom, notwithstanding what's broadcast.
I'm
to
sure
the
Court
general
TV has a
public under
better
FCC rules.
TV
Excellent. I'm glad
switchboard
to hear that.
operator
Yeah,
than the
and I
court
would like to
does.
know for the record that the Court TV was very accommodating and very helpful in that regard, and we appreciate that.
And as a reminder, so you'll see there are some cameras that have been installed in this courtroom, and some microphones. Like I have an additional microphone next to me. There's a camera down in front of the court reporter. There's a camera in the back, and there's a camera over to my left in the clerk station work area. I've also indicated, because now we may have to use the adjoining courtroom, they're in the process of getting some equipment so that there's a camera in there
I
as
find it
well.
so
I know that needs
annoying
to be worked through with the county
working as an
facilities
attorney with
because of the cabling and all of
Media.
that. So I just wanted the parties to be aware. I have approved of all of that. That brings me to a related topic, and that's the use of the courtroom microphones are still an audio backup, but we have really good microphones in this courtroom. The state noted it yesterday, or maybe it was the day before at one point. Mr. Brooks
the sound
appeared to
really
be
has been
muting,
very good.
the microphone in front of him. But because there's microphones elsewhere, we were still able to see the audio. I'd advise the state of the same thing. You have microphones behind you through the court system that just because you mute the one in front of you, you may still be picked up. And
you're giving
that
away
just
the
whispering
operation
still comes
secrets
through
to Mr.
on the
Brooks.
microphones, whether they're the courts or otherwise. So,
Could I ask a question about that, please?
sure.
During recesses, is it possible to mute all microphones so we can confer?
Absolutely.
Okay.
Remind me,
That is
right? We need the
important.
clerk to do that. But I think if we all cooperate together,
Got to keep the
we
work
will get that done.
product
Thank you.
confidential.
All right. Any questions about the broadcast, Mr. Brooks?
I didn't really understand the whole gist of it. So, I'll go with the part that I don't think that if you are not in the courtroom, that you should be privileged to see anything. I think the word you used was graphic.
I am not responsible for Court TV's compliance with FCC regulations, but it's my understanding that they
And the
will
stream for
meticulously
victims is
follow whatever
important
the
to treat them as if they
regulations are.
had room
But
in the
what's
courtroom.
In the
for all of
courtroom
them.
is clearly going to be what's in the courtroom, and anyone in the courtroom will be able to see fully based upon the monitors, including the jury, including the court, and including you, whether you're in this courtroom or the next courtroom.
Yeah, that would be the preference. If you're not in court, you shouldn't be able to see everything in court.
All right, moving on to the next topic then. There's a state's request for an interpreter. I wanted to address that because the form that you used, and thank you so much for doing that, requires that I sign an order. But it's my understanding that that request may be modified.
Yes, Your Honor, as to the timing, certainly it will be modified because I think I indicated October 6th or 7th. I no longer anticipate that being necessary. It would likely be one day next week. If you give me just a second here, I can maybe give you a better idea.
It's almost
I'm
like
wondering,
things got pushed back due to
if the court,
delays.
I hate for the court to pay for an interpreter
say
that we
lightly.
don't use. So I don't know how much notice you need to give to the interpreter or how far in advance you have to reserve them before you have to pay them no matter what. I don't know if they have rules like that or not.
They do.
Okay.
It depends.
Okay.
So thankfully, we have one local interpreter who is incredibly reasonable and I know is kind of on notice, but it really depends on his schedule. And what we may have to do as the courts, because you are correct, it's the court's responsibility to do this, to pay for it. I will not make arrangements just yet unless just based on the request that was made, because you said it's no longer a date that you would target for that interpreter. I'll decline the proposed order. And then just if you want to resubmit, of course, we have someone in the clerk's office who is parties work with regularity to obtain interpreters. And so the state can simply continue to work directly with that person to facilitate and hopefully keep the costs down. And we'll deal with whatever the fallout financially. Typically, we need 2 business days to cancel them. So if you can make arrangements, for example, say next Thursday or Friday for those witnesses to appear.
This is an example of why litigation
and
is
then you decide you
so
don't need those
expensive.
witnesses. And we
It's
should be
so
able to
much more
cancel
than
them by
just
Tuesday or Wednesday,
trial.
depending on the day that we've selected.
Sure, I understand. That's very helpful, and we will definitely be diligent to keep the court informed. I understand. I agree. It's appropriate for the court to deny my request today, and I will renew it as needed.
You know, as I think about that, I think what I'll do is I'll approve it, but I should be able to add some language about this date may be modified through direct communication between the DA and the clerk's, the person in the clerk's office responsible. I don't need you to file again and again if it's really the same request. It's just the date is changing and you're doing that in order to, frankly, save money for the county.
Yes, that's exactly our intention, Your Honor. Thank you.
Yeah, thank you. On that, let's go to the motion next, at least preliminarily. Did you serve that motion on Mr. Brooks?
No, Judge, I don't think I did, to be fair.
Uh-oh.
I had it in my office and I was gonna ask Detective Regland to take it over there, but I don't believe I ever actually did that.
All right, I will
It's a lot less
ask that you have that
less
served upon him
convenient
right now.
if you
and
can't
that will
e-file
obviously
your
impact
motions.
the timing of when I can address it. But we'll save that near the end.
Gotta give him time to read
But
it.
I'd ask that you, Detective Regland, go do that right now, and I will just pause momentarily if, so that can be done. Doing that, I'm going to take a short comfort break as well. So we'll be in recess. It's 4:06. Let's take about a 10-minute break.
And I think with that, I'm going to call it a day. I don't know if there's going to be anything super important. I'll probably figure out what the motion was, and if it was important, I'll get on early tomorrow before court starts and give a brief update. But I think that'll be a more efficient use of time than waiting. So, with that said, thanks for sticking with me. I realize I'm a tiny streamer, so it was a pleasant surprise to have someone to talk to for most of the hearing. So, Static, thank you. It really was meaningful. I'm not just saying that. I do appreciate it. I am making the commitment to, health permitting. I'm going to stream the whole trial. It's going to be a mess, I'm sure. So I I look forward to experiencing it, experiencing the mess with those of you who hang out with me. So for those of you who on the restream make it this far, I realize 3 hours is a long time. To like and subscribe. I'm hoping that through streaming the trial to be monetized at the very least by the end of the trial, but hopefully sooner than that. So like and subscribe. It'll help. And I really do appreciate it. And for those of you who join me, I'll see you tomorrow. Have a good night.